Number 1 and 2.
Motion.
Yes. Hearing.
Motion to continue.
Okay. Then I should call for hearing. Item number 3. Sorry.
It please, your lordships.
We'll take up the
This-
motion.
My lord. Item number 3.
Yes.
My lord, this matter came up earlier on 12th of February. If your lordship will kindly peruse that order, your lordship will find that the Honorable Court directed the Additional Advocate General to obtain instructions and place the matter for consideration today, my lord. That is how the matter has been listed.
Yes.
My lord, I have instruction. With regard to the incidents, the police has taken the action. They have registered FIRs. 2 FIRs have been registered. And the so-called weapon, pistol and ammunition have also been seized.
Yes. Whatever the Lingdo committee report.
This is not, this instruction is from the SP. They don't have the Lingdo committee report compliance.
Hmm.
It's not available.
We'll give that.
There has to be some inquiry whether Lingdo committee report is being followed.
Okay, this criminal, the FIR has been registered, it's under investigation.
Yes.
We can understand. But
Yeah.
then when you will have to follow the Lingdo committee,
Yes, my lord. For that, we will have to take further necessary inquiry into that.
My lord, if I may submit, my lord. If I
Yes.
may submit. My lord, if your lordship kindly comes to Annexure C at page 84, I have annexed some photographs that will show, my lord, how the violence has erupted. Even, my lord,
Page-
page 84. 84.
84.
My lord. 84 onwards. Firearms have been carried and, my lord, the shots have been fired. And this, my lord, happened because of the fact that, my lord, there is a constitution of the All Arunachal Pradesh Students' Union, and that requires certain procedure to be followed for holding the election. That procedure having not been followed, this violence erupted. In fact, my lord, that is on 30th of January. Then thereafter, if your lordship kindly comes to page 87, Annexure D. Page 87, has your lordship got it, my lord?
Yes, 87 is Annexure E.
Annexure D, my lord.
E.
Uh,
There's no
Annex-
Annexure E.
Annexure E is 88. Annexure 7 should be. There is a election notification. Has your lordship got it?
Yes. It's over now.
No, my lord. In fact, what happened? Their constitution requires that before registration of a nomination, that has to be notified. That was not notified, and because of that, the violence erupted on 30th of January. Now, thereafter, this on 5th of February, this election notification has been issued, by the Chief Election Commissioner. There is an election commissioner of the, my lord, of the APSU under the, my lord, Constitution. And this
Yes.
notification shows that, my lord, the issue of nomination papers will be started on tomorrow, 17th, and the voting will be voting will be on 22nd of February. Now, my lord, my prayer before your lordship is that, my lord, since the entire process was initiated, even not adhering to their constitution, I am praying for a stay of this notification.
It will be difficult, sir. Hmm?
Lingdo committee report
See,
comes
so
later,
far,
my lord.
so far as the incident is concerned, registered, the police has taken action and when they have filed, case has been registered, it's under investigation.
True, my lord.
And so far as the Lingdo committee report, we are not able to, we have no instruction. I mean, the state has no instruction.
My lord, can that instruction be had before the, my lord, the voting takes place? Because, my lord, at this stage, I understand, my lord, your lordship may not like to stall the process. But then, my lord,
Yes.
the violence started because of that only, my lord. If I may
Yeah,
draw your lordship
but-
attention, my lord,
Violence, it's okay. It's they have taken an action already initiated.
yes,
It's a
my
matter
lord,
of
but
investigation.
so far as the election is concerned, my lord, the root cause of the violence is, my lord, the violation of the constitution of the APSU itself, my lord. May I draw your lordship attention to the constitution, my lord, which starts at page 27. One particular, my lord's article I'd like to draw your lordship attention to at page 63. Page 63 is the how the, my lord, the procedure for election is to be followed. That has been, my lord, specified in Article 20 at page 63. Election rules and procedure of the Executive Council members. Now, at clause C, your lordship will find down below, the election commission shall be appointed by the president with due consultation with the Executive Council. Then, my lord, your lordship may skip and come to clause E. Next page. The registration of delegates to prepare the electoral college of the union shall be done at APSU office Itanagar or at any other appropriate place with proper notification for the convenience of the students at least 15 days prior to the general conference come election, and final voter list shall be prepared and submitted to the election commission by the delegates registration committee, and such list shall be published 15 days prior to the date of polling. Now, my lord, both these requirements have not been fulfilled, and that is the reason why the violence erupted. So, my lord, now putting aside the Lingdo committee report, even they have to abide by their constitution.
It's okay if there's a violation and if it's not, constitution is not, followed. you
Constitution
approach the
has not
civil
been.
court. Anyone can approach the civil court, not by a writ petition.
My lord, the
Perhaps.
matter, in fact, my lord, this matter involves the general public
Who-
because your lordship knows
who
the
are-
influence.
Who are you?
My lord, I am a general citizen. In fact, my lord, I was earlier associated with the my lord students body, but now I am not there. I have stated in paragraph 2 and 4 about, my lord, the status of the petitioner. If your lordship kindly comes to paragraph 12, paragraph 2, my lord, page 5. Paragraph 2, I have stated that the petitioner is a former president of All Tirap Students Union. The petitioner has no stake or is running for any of the posts of the Executive Council or of the or APSU scheduled to be held on 22nd February. He has no personal interest. I have also stated that in paragraph 4 that this instant public interest litigation has been filed after expiry of the present Executive Council and has been occasioned by numerous unfortunate and unsavory incidents that has marred the sanctity of the elections for the Executive Council of the APSU. Being aware of the incidents that had transpired in the aftermath of the expiry of the present Executive Council, the petitioner, as a responsible member of Arunachali society, as well as being a former president of the All Tirap Students Union and being a well-wisher of the student fraternity, has been constrained to prefer this humble petition before this honorable court. Therefore, my lord, so far as the locus is concerned, my lord, he doesn't have any personal interest. He cannot contest the election.
Are you still a student?
No, my lord. He's not a student now. Since he was earlier associated with the APSU, he has, my lord, concern about the body, because, my lord, this APSU has a large number of, my lord, members all over the state of Arunachal Pradesh and beyond, my lord. They have got their union in, my lord, Meghalaya, Assam, West Bengal, and National Capital of Delhi, NCR. So large number of, my lord, students are involved. And in fact, my lord, their activities influence the, my lord, life of the common citizen in Arunachal. That is what has happened on 30th, my lord. Therefore, my prayer would be, my lord, your lordship would like to, my lord, stay the process, because, my lord,
What is the Lingdo committee report?
Lingdo committee report is at, my lord, Annexer E, page 88.
88.
Five, 4 and 5. And president of the
Now, my lord, the Honorable Supreme Court has, my lord, say that issued direction that the suggestions given by the Lingdo committee should be implemented. And that your lordship will find, my lord, of course, since I am on BC, my lord, it has been reported in 2006, volume 8, SCC 304.
For students election also?
Yes, my lord. And that has been, in fact, my lord, the brief summary has been given in the judgment of this Honorable Supreme Court, where, my lord, the recommendations have been directed to be implemented. That is at, my lord, 2006, volume 8, SCC 304. University of Kerala versus Council Principals College, Kerala. If your lordship, court person can, my lord, help with the book, my lord.
2006.
2006, volume 8, SCC, page 304.
Yes.
My lord, may I read paragraph 2? We have perused the report of the committee constituted by the Ministry of Human Resource Development, Government of India, in terms of the order of this court dated 12/12/2005. The committee headed by Mr. J.M. Lingdo has submitted the report making the recommendations and suggestions relating to students' union elections. we are prima facie of the view that the recommendations need acceptance, and as an interim measure, we direct the following recommendations to be implemented. Now, the recommendations are at, my lord, paragraph 3, and finally at paragraph 7, my lord, the direction has been given and some observations have been made. Paragraph 7, my lord, at page 313. During the course of hearing the petition, Mr. So-and-so, learned Assistant Solicitor General, brought to our notice the need for a direction to provide security to the academic community who are involved in the process of students' union elections in the universities and the colleges. It was suggested that to ensure the protection, the Dame Superintendent of Police in charge of the area shall provide enough police protection and shall ensure that no untoward incident takes place by providing adequate number of police personnel to be posted near the place of election. The suggestions appear to be wholesome. We direct that the suggestions given be implemented as and when the necessity so arises. It is made clear that the recommendations made, which we have accepted to be adopted as an interim measure, shall be followed in all college university elections to be held hereinafter until further orders. So in view of this direction of the Honorable Supreme Court, my lord, the recommendations of the Rainbow Committee report are to be, my lord, implemented, and my lord, the police authorities are to be directed to ensure that no law and order situation arises. This is my limited submission, my lord, on the basis of this judgment of the Honorable Supreme Court. My lord, since I have shown your lordship that the constitution of the APSU has itself not been followed. Therefore, my lord, the election has to be, my lord, stalled for the time being, my lord, till they file their affidavit and, my lord, come up with their, my lord, reasons. My lord, even otherwise, the term of the earlier committee expired in December. The election ought to have been held in December, but my lord, ad hoc committee is now functioning. And my lord, waiting for some, my lord, days or weeks may not make any difference, my lord. The earlier term has
Sir,
already.
We're not inclined to stay the election process, but then we can issue notice and we may direct them to follow the Supreme Court judgment. That's all. And so far as the violence is concerned, it has happened.
My lord.
And action has been initiated by registration of FIR. It's under investigation. It will be taken care.
My lord, I think that will protect us in the sense that protect the students, my lord, who are democratically, my lord, they want to participate. I'll agree to that.
So we are not stalling the election process.
But then, my lord,
Make
your
an-
lordship will
Make an observation, if they will mention this direction, observation of the Supreme Court.
my lord.
And hope, most probably they are, I think, following, not letter in spirit. May not be letter, but then hopefully spirit are being followed.
My lord, in that event,
It's
may
not
I
a
pray
first,
that,
I think it's not a first election, 27th election. Is it 27 election?
in fact, my lord, there have been
27th
amendments.
election of, yes.
Yes, my lord. In fact, my lord, there have been amendments of the constitution, their constitution, my lord, that has created the problem. Now, my lord, may I pray, my lord, since your lordship is not inclined to, my lord, stall the process of the election, but then some conditions your lordship is imposing, my lord, may I pray that, my lord, results may not be declared till the next day, my lord, when they file the affidavit.
No, that is indirectly amounting to interference again.
No, my
Stall the
lord,
process.
they can file it very early, my lord. They can file it very early.
Heard Mr. M.K. Chaudhary. learned senior counsel assisted by
Mr. P. Bharadwaj is there.
Mr.
Mr. P.
Bharadwaj, P. Bharadwaj,
Aye.
learned counsel for the petitioner. This petition has been filed by the petitioner in the form of public interest litigation in connection with the election of the All Arunachal Pradesh Students Union, alleging violation of the constitution of the
constitution. Their constitution.
constitution of the APSU, comma, law and order issue, as well as non-compliance of the recommendation of the JM Lingdo committee as regards the election of students, which has been affirmed by the judgment of Honorable Supreme Court in the case of University of Kerala, bracket, one bracket close, versus Council, Principals, Colleges, Kerala and others, reported in 2006, 8 SCC 304. This court on 12/02/2026, upon consideration of the matter, had directed the learned additional advocate general Arunachal Pradesh to obtain instructions. This stuff. That will be next para, when Mr. N. Ratan, learned additional advocate general, while placing the communication from the superintendent of police Itanur ICR, Arunachal Pradesh, has submitted that the police has already registered 2 FIRs, registered 2 cases, being Itanagar PS case number 18 of 2026 and 19 of 2026, and the matter is under investigation. And the authorities will take appropriate actions and to bring the matter to its logical conclusion, strictly in accordance with the law. Regard being had to the non-compliance of the Lingdo committee report, he submits that he may be granted some more time to obtain the instruction.
It's not available. It's not available. So some more time may be granted.
Not available.
Yes.
Some more time to obtain the instruction, as he has not been provided with the instruction today. Listen. Issue notice. That's all. Issue notice returnable by 3 weeks. Is Mr. Who else are appearing?
I'll be appearing for 1, 2, and 3.
Yeah, Mr. Just wait. Since Mr. N. Ratan, Additional Advocate General, enters appearance and accept notice on behalf of respondent 1, 2, 3, and Mr.
Respondent 4 and 5.
N. Jolo, Nabam Jolo,
Navam.
Nabam Jolo, Learned Council, enters appearance. No, and for respondent 4 and 5.
My lord, he can appear for 6 also
Yeah.
because that is a part of.
No,
No,
he's appearing. Somebody is appearing.
I'm not served with the copy of writ petition.
The Mr. N and Mr. Aringo, Learned Council for respondent number 6. No formal notice need be served. However, extra copies be furnished to the Learned Council for the response. Next pair. देखना पड़ेगा क्या क्या है बताइए having considered the allegation of non-compliance of this recommendation by a committee headed by Mr. James Lindo way back in 2005, which has provided which is recommended and suggested related to the students' union election and the which has been affirmed by the Honorable Supreme Court in the case of University of Kerala within bracket super. We provided the suggestions given by the be implemented, be followed. The Lindo committee report, which provides suggestions, be implemented in terms of the observation made by Honorable Supreme Court in the censor University of Kerala Supra. That's all.
Only one prayer, my lord. Your lordship said about the non-compliance of the Lindo committee report. Your lordship may kindly observe also that, my lord, non-compliance of the constitution itself.
Yes, I have mentioned.
My lord.
I've said so.
My lord.
Non-compliance of the recommendation, violation of their constitution,
Yes, ma'am.
and the law and order issue. Problem, right?
Your lordship will kindly fix a date, my lord, after 3 weeks.
After 3 weeks,
A date may be given.
That is on 12th.
12th March.
Highly obliged.
Yeah, obliged.
Item number 1 and 2.
May I, my lord?
Yes.
My lord, the brief background of the case is that, my lord, the entire writ petition was, my lord, directed against a file noting, my lord. The writ petition itself was not maintainable, my lord. The writ petition was filed against the file noting, my lord. So, my lord, there could not have been any, my lord, relief could not have been granted to the writ petitioner.
Hmm.
In fact, the writ petition itself was not maintainable, my lord.
Hmm.
It's a settled law, my lord. File noting does not create any right to any person, my lord.
Unless it is culminated into an order.
Yes, my lord.
Then
My lord, page 139 is the file noting, my lord.
page
139, my lord.
139.
Now, my lord, what happened? The headquarter board, my lord, had received, my lord, recommendation from the district board, my lord. So the headquarter board has prepared this file noting, my lord. Page 139, my lord. It is of 2nd May 2025, my lord. Right side, my lord, on the top, my lord. This file noting was quashed, my lord, was interfered by this honorable court by the learned single bench, my lord. In fact, my lord, the bid of the respondent number 1, my lord, was rejected, my lord. Right order dated 29/5/2025, my lord, which was never put to challenge, my lord, by the writ petitioner, not by way of amendment, anything, my lord. It stands still, my lord. It is in page 140, my lord, in the file noting of 29/5/25, my lord.
Where it is?
Page 140, my lord, on the top, my lord.
After scrutiny
Yes, my lord.
to the NA.
This is the file noting of 29/5/2025, my lord.
Who is the petitioner?
Respondent number 1, my lord.
Respondent number is you.
LY, my lord. LY Enterprise, my lord. LY Enterprise.
So his case was rejected
Yes, my lord.
by
His, not by this, my lord. There was a process, my lord. It can be seen on page 194, my lord.
after scrutiny, the NIT documents, the
Yes,
following
ma'am.
forms have found to be the responsive form as below. Who is the petitioner?
LY Enterprise, my lord.
It was found responsive. LY Enterprise. LY Enterprise.
LY Enterprise, my lord.
Then,
For some other block, my lord. For some other block, my lord.
then,
This is regarding a Chetam CD block, my lord. Now, LY Enterprise was, my lord, found responsive for Dapurja block, my lord.
then how is this is connected?
This is the file noting, my lord.
Chetam,
Yes. It concerns the Upper Subansiri district, my lord.
package 8. Package 8.
Package, my lord.
Chetam.
Yes, my lord.
Serial number 7.
Yes, my lord.
Approved, quoted, rejected.
Other enterprise, my lord. 7, other enterprise, my lord.
Who
For-
is the petitioner, sir?
LY Enterprise, my lord.
Then
Now,
LY is serial number 7.
serial number 7, my lord, other enterprise. Page 140, my lord.
Approved.
Yes, my lord.
RR Enterprise
Was approved, my lord.
and MS Solo Enterprise also approved. Port Chetam.
No, my lord. Page
139,
139, my lord.
serial number 7.
Yes, my lord. This is only a file noting, my lord. Approved. Responsive for, my lord. This is the final submit, my lord. Noting, my lord. My lord, there was various mistakes. We have also taken the plea in our affidavit of opposition, my lord. There was various mistakes in this file noting, my lord. Page 139, my lord, of 2/5/25, my lord.
Then
Despite that, my lord, learned single judge has interfered, my lord. Page 194, my lord, may I please come to page 194.
you have corrected this. You have not accepted this.
Yes, my lord. There is very many mistakes, my lord, in the page 139.
This file noting 139 has been accepted or no?
We have accepted, but there are many mistakes in the page 139, my lord.
So this was rejected. MSLY Enterprise was rejected
Yes, my
by
lord.
this page 139. And other two firms are found to be responsive. No,
Not rejected, my lord. Here, so number 7 not rejected. My lord.
it's written, rejected.
Oh, yes, yes, my lord, rejected. Yes.
Responsive firm approved date so and so, then approved so and so.
This is the, my lord, replica of the file of the board proceeding of the district board, my lord,
Hmm.
which was concealed by the writ petitioner during filing of the writ petition, my lord. My lord, this is the
Where is
replica.
your final order?
Final order is page 194, my lord.
194.
Yes. It starts with 194, my lord.
Hmm.
One 196 is the conclusion, my lord.
196 is?
The conclusion, my lord, the approval part, my lord.
Ah.
Order was approved, my lord. And subsequently, LOI also issued to RR, my lord, page 197, my lord.
Hmm.
This LOI and this order has never been challenged, my lord, by the writ petitioners, my lord.
This subsequent to that page 139. Huh?
Not subsequent, my lord. It must be prior to.
Sorry.
It is because of the reason, my lord. After scrutiny, my lord, page 140 starts with after scrutiny, the NIT documents the following files, my lord. This
This
file,
is on 1st of May.
29th May, my lord.
Huh?
29th May,
Where do you get it?
page 194, my lord. On the right side top, my lord.
But your detail is page 195.
Yes,
Dated date time 01. 1st May.
yes, my lord.
Huh?
This is a scrutiny process, my lord. The order was passed on 29 May, my lord.
Hmm.
Page 194 has a bearing with file noting of 29 of page 140, my lord.
Hmm.
194, my lord, and 140 may be read together, my lord.
140.
Yes, my lord. After scrutiny. This file noting is of 29/5/2025, 5:40 p.m., my lord.
Hmm?
5:40 p.m., my lord.
Hmm.
So, my lord, so scrutiny was done by separate order, my lord.
Hmm.
Both having same date, my lord, 29 May.
Proceedings are on 1st of May.
But the order was passed on 29 May, my lord.
Ah.
Page 194, my lord.
And this, your so-called office note is the 2nd of May. No.
Office note, my lord, may I read, my lord? This is concerning the entire district of Upper Subansiri,
Ah,
for entire CD blocks, my lord.
which includes the Chetam,
Yes, my lord.
serial number 7.
Yes, my lord.
Where is the MSLY enterprise was rejected?
Actual file noting is page 140, my lord. Because after scrutiny, my lord,
Huh?
it connects with page 194, my lord.
Hmm.
This, my lord, may see page 187. This is, my lord, we have to understand the content of this file noting, my lord.
Hmm.
May I read, my lord? File noting, my lord. This by above reference, project director approximately
Page,
has
page.
page 139, my lord. Top of the page, 139, my lord.
Hmm.
But above reference, project director Upper Subansiri district has submitted the technical and financial bid evaluation statement conducted of e-tender process at district level against procurement of materials under NJ to the following CD blocks of Upper Subansiri for obtaining approval from competent authority. Board proceedings of district so and so scrutiny seat of district level reference please here. This is the scrutiny made by the district board. My lord.
Hmm.
This is the replica of district board. My lord. The board proceeding, my lord, of the district board is page 187, my lord.
Hmm.
187, my lord. In the district board also, the bid of the petitioner was rejected, my lord. This was concealed, my lord, during filing of the writ petition, my lord.
Which one? By which order?
This is the order, my lord, of 11 April 2025, my lord.
Hmm.
They have, my lord, they have annexed the relevant part which is favorable to them, not the other part, my lord, where their bid was rejected, my lord.
No, this is also, by this 139, his case was rejected. Although he was found to be L1.
Rejected, my lord, because it was rejected by the district board. This is the, my lord, replica of the district board, my lord, the board proceeding of the district board, my lord.
Hmm.
Page 139 is the replica of page of district board, my lord.
Huh.
So in the district board, his bid was rejected. The headquarter board again, my lord, made a scrutiny, my lord.
District board also rejected it.
Yes, my lord. That was
And
concealed. my lord.
headquarter also you have rejected.
Yes, my lord.
Although he was L1.
We say differently, my lord. He is not
You
an.
said below, what is justified there?
Yes, my lord.
Page 194, 96.
Yes, my lord.
Rate quoted below justified rate.
Yes, my lord.
Huh?
Yes, my lord.
How do you say so?
Because the department has prepared one, my lord, justified rate, my lord. And the bid quoted by the petitioner was beyond the justified rate, my lord.
Below.
Yes, my lord.
Below the justified rate.
So, my lord, the impugn order may be caused, my lord.
Why?
Maybe interfered with, my lord.
Why?
Because, my lord, there was no relief as against the order dated, actual order, my lord.
Hmm?
Actual order, my lord. He may have grievance against the order dated 29 May, my lord.
Hmm.
But he doesn't have any right to, my lord, challenge the file noting of 22nd May, my lord.
Hmm.
And secondly, my lord, his bid was rejected by the district board and again by the headquarter board, my lord, which
There
was
is no
never put to challenge. Yes, my lord.
But rejection is 139. He has put to challenge that.
Rejection, my lord, that is the file noting of the district board, my lord.
Huh. Where is the rejection of district board?
Rejection of district board, my lord, may I please come to page 187, my lord.
Hmm.
That is why I am saying, my lord, this file noting has the bearing of only district board, my lord.
187.
Yes, my lord.
Ah.
May I read, my lord? The financial bid was opened on 1 May 2025 at 10,000 hours and was evaluated. MSRR has quoted bid price of rupees so and so, only which is less minus 7.31% than the tender cost. MS Salo Enterprise has quoted bid price of rupees so and so, which is less minus 7.23% than the tender cost. And MS Elva Enterprise has quoted bid price of rupees so and so, only which is less by minus 10% than the tender cost. However, justified rate of Chetan block is approved at 7.31% below the BOQ amount by order numbers so and so. Hence rate quoted above approved rates shall not be applicable, my lord. Hence, the board members recommend following forms for comparative statement as follows, my lord.
Hmm.
RR, my lord, L1. Salvo Enterprises, L2, my lord. LY not applicable, my lord.
According to you, this has not been challenged
Yes, my lord.
and the final order.
This is the, my lord, page 188 also, my lord. Page 188 and 189.
Hmm.
The file noting of page 194,
Hmm.
oh, sorry, 139
Hmm.
contains the extract of this page 188 and 189, my lord.
Hmm. This is by this page 87 is by whom? District Board.
Yes, my lord.
You have accepted that only.
My lord,
You have accepted the decision of the District Board.
we have, my lord, we have a SOP, my lord. We can reevaluate, my lord. So we have reevaluated, my lord. And again, his bid was rejected, my lord, by the headquarter board, my lord. By order dated 29 May 2025.
In a way, you have accepted the decision of the.
So why, my lord, they have not challenged the 29 May 25 order, my lord. The last order, my lord. And the LOI issued to the respondent, my lord, respondent number 2. My lord.
Hmm.
The writ petitioner has not filed any amendment, my lord,
Hmm.
of the writ petition, my lord.
Have you taken the ground?
My lord, yes, my
In
lord.
your
In my appeal, yes, my lord.
That has been considered. Learned single judge, considered by learned single, has it been?
No, no, no.
considered? Huh?
No, my lord. Not in the writ petition, my lord. In the writ
No, no,
appeal,
in the impugn order. Has the court, learned single judge considered your, this thing? Submissions?
my lord,
Say file note.
during hearing of the case, I was sick, my lord.
Huh?
During the hearing of this case, I was sick, my lord. Learned AG was appearing for the case. My lord.
So,
So we have, this is our pleaded case, my lord.
Hmm.
Page 169, my lord, we have categorically stated, my lord. This is only a file noting, my lord. Page 169, my lord. Paragraph 9, my lord. May I read, my lord? Our affidavit in opposition before the London single judge, my lord.
You have not taken any ground,
Page 169, my lord.
which you have taken.
Page 169.
You have not argued,
This is our pleaded case, my lord.
but you have not argued.
My lord, we have clarified here regarding the file noting, my lord. Page 169, my lord.
169.
Yes, my lord. Paragraph 9. May I read, my lord?
Yes.
That regard to the statement made in paragraph 7 of the writ petition, deponent begs to state that deponent has never witnessed challenge to internal office internal office communication by litigant. File noting is nothing but an internal correspondence. It gives no right to the petitioner. It is submitted file noting that the two files containing table is an abstract of technical and financial bid evaluation of district board. My lord. We have clarified here. Where there are some mistakes. In fact, in the table of departmental file noting, in one case, one firm, namely Duxton, MS Duxton Enterprise, was also not reflected in the case of Nacho CD block, and in another case of Dumpurja CD block, the amount of bid has been wrongly mentioned. Nonetheless, during evaluation of bid documents of bidders by headquarter board, incorrect file noting was not taken into consideration, but actual bid documents of the bidders were taken into consideration. By that, as it may, the observation after the table, after scrutiny in the file noting has been made on 29/5/2025, 5:40 p.m., my lord, which is based on the order dated 29/5/2000, where the headquarter board had evaluated, scrutinized the tender documents of the bidders. Whereas the opponent would like to reiterate statement made in para 7 and 8 of the stand affidavit. This was our pleaded case, my lord.
But you have not argued at the time of hearing.
That, but my lord, in the appeal also it can be, my lord, seen, my lord, whether a file noting can be, my lord, file noting file noting
There is no-
gives any right to the litigant, my lord.
So your simple case is that since it was a file noting,
Yes.
it has not been culminated into an order.
Yes,
and
madam.
the order of rejection
Yes,
or the consequent order. Final order
that was a
is not-
defective
not
file noting,
put-
my lord.
Put to challenge,
Yes, sir.
therefore, this could not have been interpreted.
Yes, my lord. And the subsequent development also, my lord, not challenged.
What subsequent?
My lord, LOI was issued to the respondent, my lord.
Ah.
RR Enterprise, my lord.
Hmm.
It was not never challenged, my lord, by way of amendment, my lord.
I think very inconsequential once you have decided the matter, determined the matter.
No, my lord. So they could have challenged, my lord, by way of amendment, my lord. I have one, my lord, citation of single bench, my lord.
What citation?
This is, my lord, Tamak fabrication, my lord.
Hmm?
Tamak fabrication, my lord.
Hmm.
Subsequent development, my lord, has not been challenged.
Which one?
Petition 2022 GLR 261. 26. Para 24, my lord. Yeah, my lord. The writ petition was filed on 7/12/2018. There is no amendment in the writ petition that the petitioner was not aware of the comparative statement, which disclosed that despite the petitioner being L1 bidder, recommendation was made for approval of the work in favor of the appellant, as the rate quoted by the appellant was within the permissible variation of clause 20 so and so. The rate quoted by the appellant was within so and so of CP1, while the rate quoted by the petitioner was so and so. Even if it is assumed that the petitioner was not aware of the fact that petitioner had emerged as L1 bidder at the time of filing of writ petition, there is no escape from the conclusion that after the comparative statement was annexed in the affidavit of the respondent number 4 and 5. Here also, my lord, we have annexed the rejection order, my lord. The petitioner had become aware of the fact in the matter of present nature relating to award of contract in respect of public road, it is necessary for a writ for the petitioner invoking writ jurisdiction to set up specifically relief's claim. The petitioner did not amend the writ petition to incorporate any challenge for rejection the bid of the petitioner, even though submission have been made during the course of the argument by so and so. That rejection of the bid was illegal and arbitrary as per CPW mentions. Applies only to situation where a bid is above so and so. Over the estimated price and not when the bid is lower than 5% or 10% of the estimated price. There is no pleading to the effect. Even in the affidavit in reply to the affidavit of the respondent number 45, no specific ground is taken as to why rejection was illegal and arbitrary, save and except stating that CPW Manual 2014 is only a guideline. If a challenge was mounted in accordance with law regarding rejection of bid and the bid was recorded against the petitioner, it may have been to the petitioner to assail the rejection as well as to question the decision rendered in so and so. In above background, we do not consider it necessary to make any further discussion on so and so. It appears the decision in so and so supra was not brought to the notice of the learned single judge. The submission was articulated on behalf of the appellant that the petitioner having been disqualified in the financial bid, the writ petition was not maintainable and no relief can be granted to such a petitioner. The aspect of the matter was not at all considered by the learned single judge. On the principle that existence of right is the foundation exercise of the jurisdiction of court under Article 226 of Constitution of India, and when a petitioner has not shown that he has any right in the subject matter of dispute, he cannot come to court and ask for writ to issue. The petitioner having not assailed the rejection of his bid, further proof on the contentions raised by such a petitioner would not have been really called for. So no interference could have been done by the
Division bench judgment. It's a writ appeal. It's a writ appeal.
yes, my lord. Yes. But for reference, my lord, yes.
Huh?
This is my lord, this is writ appeal, my lord. Yes, my lord.
Why you say the single judge?
My lord, because the name written here only Justice Manish Chaudhary.
This is the problem with Supreme today.
My lord.
Para 24.
24, my lord.
24. Para 24.
Yes, my lord. So, my lord, they have not filed any amendment, my lord, by assailing, my lord, particularly the rejection of his bid, my lord, of order dated 29 May 2025. And my lord, file noting, writ itself is not maintainable. Because against my God, we have seen, my lord, because the file noting of 29 May is different, my lord. 2 May is different, my lord. 29 May says, my lord, after scrutiny, my lord. And where is the scrutiny? Scrutiny is at page 194, my lord. 139 has a reference to page 194, my lord. Because both of them carry same date, my lord. Page 140, my lord, is of 29 May 2025, my lord. And the order itself was of, and the rejection of his bid, my lord, is of 29 May, my lord, 2025, my lord.
29 May.
Yes, my lord. Same date.
Finally.
Yes, same date.
Initially by whom?
Initially by the
By
district board.
district
my lord.
board?
Yes, my lord.
On which date?
On April, my lord. 1st of April.
Then this file noting is of 2nd of May,
Yes, my lord.
which has been the evaluation or whatever is of the district board has been
Yes, yes.
accepted.
Yes, my lord.
Okay, that's all.
Yeah, that's all, my lord.
Yes. Why did two writ appeals?
My lord,
Single order.
same order, my lord. I'm for the,
Same impugn order. But,
Yes, ma'am.
You are RR.
yes, my lord. I'm the
Today,
beneficiary and respondent number 5 in the writ
Yes.
petition. My lord, here,
May I interrupt, my lord?
You have filed a separate.
separate appeal. my lord.
Okay.
May I, my lord?
Item 2. Yes.
I have led on Santi Sports, my lord, 2009, my lord.
Saying what?
Writ
On,
not,
on what point?
File noting, my lord.
File noting.
Yes, my lord. File noting does not give any right to the litigant, my lord. It is only an internal correspondence, my lord.
Hmm.
2009,
It's
15.
not a internal correspondence.
It-
File noting is file noting.
Yes, my lord.
It's not a correspondence. Anyway, no?
2009, 15 SSC, my lord. 705, my lord. Paragraph 42.
Read it.
Yes, my lord.
But it was not related to tender. Santis.
Yes, Santis.
It was not related to tender.
But the principle of law, my lord, that
No,
has
I'm
been enunciated,
asking,
my lord.
what is the fact here?
Text is regarding, my lord, acquisition, my lord.
Hmm. Acquisition of
Land.
land.
Yes, my lord. Merit, my lord.
7. Page number.
Page number, my lord, 705, my lord.
Where's that? Yeah, to me, do it. Para?
Paragraph 43, my lord.
Yes.
A noting recorded in the file is merely a noting simpliciter and nothing more. It merely represents expression of opinion by the particular individual. By no stretch of imagination, such noting can be treated as decision of the government. Even if the competent authority records its opinion in the file on the merits of the matter under consideration, and same cannot be termed as a decision of the government unless it is sanctified and acted upon and by issuing an order, my lord. And my lord, page 727, my lord, paragraph 44, my lord. Internal paragraph 9, my lord. Paragraph 44.
Hmm.
Merely writing something on a file does not amount to an order, my lord. Before something amounts to an order of the state government, two things are necessary. The order has to be expressed in the name of the governor as expressed so and so.
Para?
Para 45, internal para 9, my lord.
Hmm.
Merely writing something on the file does not amount to an order, my lord. Obliged, my lord.
Here, my lord, in the writ petition, I have not filed any separate affidavit. I relied on the affidavit by the state, and an extensive argument was done on 3rd of November 2025. Man. But in the judgment, my lord, none of my submissions have been reflected, man. And now, to the extent that my client now thinks that I am in collusion with the writ petitioner, now, nothing has been recorded, my argument. Now, my case here is, other than what has been advanced by my brother for the appearing for the state. My case is that when the bid of the petitioner, it has been rejected in terms of the clause 20.4.3.2 of the CPWD manual, whether this court can sit as an appeal and interfere with the finding of the court. Whether L1 should necessarily be awarded the work. That would be my basic argument.
Are you admitting that the petitioner was L1?
Petitioner, yes, by the rates, otherwise his lowest bidder, otherwise. But whether it's workable or not, that is another issue. That was what the department has said, man.
The department had said that you have had this the justified rate,
Justified rate.
which was approved.
Yes.
On that, when you take that, the rate quoted by the petitioner maybe L1, I mean lowest,
No,
but then it is below the justified rate.
below the justified, my lord. Now, my lord, finding of the board, my lord, I will,
But 20.4.2 of CPW manual,
No.
when you are relying, they are relying,
no,
it talks about the if it is below 5%
not below, my lord. It is when it is
Within-
over, my lord,
or above.
above, my lord. But before that, my lord, I will take your lordship to just the financial with evaluation, my lord, in WA 21, my lord.
21.
21. Page 169, man.
No, no. Page
169. Basically, this is what has been accepted by the board at Itanagar also, by the headquarter. This is by the district board, man.
69. Yes.
This is name of work, supply of so and so, tender amount so and so. The financial bid was opened on 1/5/2025 at 1000 hours and was evaluated. Number one, my lord, this is the appellant here, my lord, has quoted price of so and so only, which is less by minus 7.31% than the tender cost. Number two is measures so and so has quoted bid price of so and so, which is only less by minus 7.2 than the tender cost, and MSLY Enterprise had quoted bid price of so and so, which is less by minus 10% than the tender cost. However, the justified rate of Chatham block is approved at the rate of so and so, white order number so and so. Hence, the rate quoted above approved rate shall not be applicable, man. This is what the finding is, my lord. Here now, my lord should come to page
What
Two.
does it mean? Hence rate quoted above
above
approved rate.
approved rate shall not be applicable. Basically, here the rates have been mentioned, man. Now, if your lordship would come to page, I will take your lordship to the CPWD manual, my lord. I have annex here, my lord, at page 208, my lord.
Zero eight.
208, my lord. It starts, my lord, with the relevant portion. Section 20 is the receipt, opening, and acceptance of tender, my lord. Now, if my lord may come to page 213, my lord. The purpose why that is 20.4.3, my lord. Reasonability and competitiveness of rates. The tender accepting authority shall satisfy himself about the reasonability of rates before acceptance of the tenders. Reasonability of the rates shall be primarily assessed on the basis of justified rates. The mode of preparation of justified rates is detailed in the following paragraph so and so, my lord. Now at my lord may come to 20.4.3.215, my lord. Acceptance of tenders at justified rates with allowable variations. A proposed variations or provisions under para 20.4.3, my lord has seen that, my lord. It is regarding the workability of the rate, my lord. Variation up to 5% over the justified rates may be ignored. Variation up to 10% may be allowed for peculiar situations and special circumstances. Reasons for doing so shall be placed on record. Tender above this limit should not be accepted, my lord. Now, my lord knows it says over the justified rate. It doesn't apply when the bid is below the justified rate. Now, by virtue of having been in the having appeared for the government earlier, my lord, when this 2014 manual came out, my lord, it was deemed to be minus or plus on both sides. But subsequently, it was what evolved during or after the various cases and the matters pending before this court, that these matters were decided. What evolved was that it means it over the justified rate. Quoting below the justified rate, there is no bar. And if the rate is workable, my lord, because if the rate is low, it will always be beneficial for the department and the state. But there might be circumstances where the bidder work might not be cannot be executed in under the estimated cost. Then at times the bidder might go over the price also. So the justified rate, when it says 5% over the justified, it has to be read literally, my lord. It cannot be meant to include below -% or over -%. Nowhere the department has said, my lord. Sorry, my lord. The department always says since it is below the justified rate, it's not applicable, and then the rate is not workable, my lord. Now, my lord, my brother has this writ appeal also, my lord. My brother was reading at para 24, my lord. Here, of course, it's a submission, my lord, but may I take your lordship to that particular line, my lord. The judgment my brother Mr. Picha has given, my lord.
Yes.
Para 24, the last line, my lord. Of course, it is a submission, but what have been submitted by the learned senior councilman, even though submissions have been made during the course of argument by Mr. I. Chaudhary, the rejection of the bid of the petitioner was illegal and arbitrary. As CPWD Manual 2014 applies only to a situation where the bid is above 5% or 10% at the most over the estimate, and not when the bid is lower than 5% or 10%. So here is also a similar case, my lord, where it clearly says over the justified rate. It cannot be interpreted, my lord. My lord knows the author of the tender document is the best person to interpret it, my lord. Now, what the department has said, my lord. My lord will come to page 147 of my appeal, my lord. Or 145, my lord.
Yes.
My lord, the last paragraph, my lord, also, this is the affidavit filed by the state, my lord. Here it is to submit that the petitioner cannot take shelter of auto-generated L1, which is based on lowest bidding and completely beyond the scope of justified rate. If lesser bid is taken into consideration, a bidder may quote -10%, 20%, or -50% just to get the tender work. Auto-generated rank does not give any right to any bidder. For adjudging L1, there are many factors like consideration of workable rate, etc. Be that as it may, in the instant process, the tender board has processed and evaluated tender bids on basis of justified rate prepared by the department. Taking into account all such factors, the project director of the analysis have prepared so and so, this, my lord. The workability, my lord, it has to be seen. Now, my lord will come to page 147, my lord.
Yes.
Para 8, my lord. That with regard to statements made in paragraph 6 of the writ petition, the Ribbon begs to state that on receipt of tender documents from district level board, headquarter level board on 29/5/2025 had evaluated, scrutinized the tender documents of the community block of Upper Subansiri district. On scrutiny, finding bid quoted by Mr. So and so, amounting to rupees so and so to be most feasible as per justified rate of the department. Thus the same was adjudged N1. Again, finding bid quoted by measures so and so has quoted so and so to be the most feasible as per justified. Thus the same was adjudged L2. The financial bid of measures LY intervention, a petitioner, my lord, amounting to rupees so and so was found responsive and rejected as the rate quoted by the firm was below the justified rate, ma'am. On such recommendation, so and so, ma'am. The department says it's not workable, madam, because otherwise also it's 10% below the estimated cost also, madam. Now the
10%.
10%
10%.
below the estimated cost, my lord, and
Justified.
otherwise it's almost around 3% below the justified rate, my lord.
3% below.
Around 3% below the justified rate, my lord,
Okay.
and 10% below the estimated cost, ma'am.
Okay.
Now the learned single judge has said this 5% variation, it should be applicable on both sides, madam.
Okay.
That is what basically has been said. Now, coming to the impugned judgment, madam,
Either above or below.
above or below, madam.
But you have rejected them on number one is according to your first feasibility.
Feasibility,
Number
madam.
two, rejection is just because the rate quoted by the petitioner is
Hmm.
2 or 3% below the approved rate.
Below the justified rate, and it is not workable. That is what the department has said.
Justified rate is 7 point.
Minus 7.31 for
Okay.
below the estimated cost, man.
Ah.
Now, and the bid of the read petitioner was minus 10% below the estimated cost.
Yours is
Mine is minus 7.31.
so Learned Single Judge has held that it should be applied in both
Basically,
above
if
and below.
below, my lord.
The two.
There is no reasoning
4.3.2.
20.4.3.2 applying that, man.
Ah.
There is no reasoning as such why that decision has been arrived, my lord. If your lordship would come to page 228, my lord,
Hmm.
the impugned judgment.
228.
228.
Yes.
Para 21, 22, my lord, that 20.4.3.2 has been quoted, ma'am. Now 23 onwards. ma'am.
Hmm.
Thus, I find that variation of 5% vis-a-vis the justified rates are allowed to be ignored and variations above 10% are held to be not acceptable and such bids have to be rejected. It is also provided that variations up to 10% can be allowed, but for peculiar situations and special circumstances and reasons for doing so have to be placed on record, ma'am. My lord, from where, my lord, the journalist just finds that the variation or justified up to 5%, it has to be allowed on the both sides, my lord. Now, number 20, para 24, my lord. The whole objective behind this exercise, as mentioned earlier, is to ensure that uncompetitive bids are not accepted, which can compromise the work. When other things are equal, the authorities are encouraged to accept the lowest bidder in public works involving public money. Now, para 25, my lord. Now I come back again to the facts of the instant case. As already stated, in terms of NIT dated 11/4/2025, the tender value is 5 crore so and so. The justified rate is quantified at so and so, and in percentage terms, that is 7.21. This should be minus 7.31, my lord. In monetary terms, the so and so. Petitioner's bid was quantified at so and so, and in percentage terms, the said bid has had a variation of 2.9% vis-a-vis the justified rate. This is minus 2.5, my lord, below the justified rate. Para 26, my lord. The respondent authorities have held that the bid of petitioner firm was 10% below the justified rate. This is, my lord, this finding is others also wrong, my lord. The department has said it's 10% below the estimated cost, not the justified rate, my lord. This is a wrong finding, my lord, and therefore not acceptable in terms of applicable guidelines. However, I find that the petitioner firm in its affidavit in reply has contended that the variation of the petitioner firm is 2.9% below the justified rate and therefore was within the permissible limit as per clause so and so. It is an admitted position that the bid value of the petitioner firm was the lowest financial bid so and so. Now, the learned single judge has erred on this point that the department is saying, the state is saying that the bid is below 10% of the justified rate. In the finding, it is only been said it's 10% below the estimated cost and the below the justified rate. And otherwise also, it's not workable, man. Now, can that view be substituted by the learned single judge, man? my lord knows, my lord, the procedure, my lord, my lord has seen, my lord. Whether it is so perverse that extraordinary jurisdiction, my lord, is invoked and then the contractual matters have been interfered with.
So I've considered view that soon made an error in holding that the bid of petitioner was 10% below
Yes, my lord,
the justified rate,
my lord,
whereas in fact it was below the 2.9
my lord.
and within the permissible variation of bracket 5% in terms of. So according to this 2.4.3.2,
My lord.
which provides the variation of above 5%.
Over the
Yes.
justified rate.
Huh?
Over the justified rate,
Justified rate
my lord.
cannot be applied here because the rate quoted by the petitioner
My lord.
is below the
Justified rate.
justified rate, maybe 2.3.
2.9, my lord. 2.9, my lord.
Minus 2.
2.9% below the
Justified rate.
justified rate and 10% below the estimated cost.
Estimate.
ma'am. Yes. Now the learned single judge has on this basis, my lord, said that it is 10% below the justified rate, which is incorrect, my lord. And it is said that below the justified and therefore was within the permissible limit as per clause so and so, ma'am. But that clause has to be read literally, my lord, which says over the justified rate, ma'am. Because if it is below the below the amount, my lord, lesser the amount, my lord, the state has nothing to lose, my lord. But only the workability has to be seen, my lord. I will not burden your just I'm sorry, my lord. I just have one copy, my lord. Extremely sorry, my lord. I will just read one paragraph from them. Otherwise, the evolution of the bid and
Ronak International.
Ronak International. my lord. Just para 16, my lord. Just one paragraph, my lord. I'm extremely sorry, my lord, that I did not bring the sufficient copy, my lord. Para 16, my lord. It is also necessary to remember that price may not always be the sole criteria for awarding a contract. Often when an evaluation committee of experts is appointed to evaluate offers, the expert committee's special knowledge plays a decisive role in deciding which is the best offer. Price offered is only one of the criteria. The past record of tenders, the quality of the goods or services which are offered, assessing such quality on the basis of the past performance of the tenderer, its market reputation, and so on, all play an important role in deciding to whom the contract should be awarded. At times, a higher price for much better quality of work can be legitimately paid in order to secure proper performance of the contract and good quality of the work, which is as much in public interest as a low price. The court should not substitute its own decision for the decision of an expert evaluation committee. The committee finds that the work bid of the writ petitioner is not workable, man. Can this court substitute it, man? And man, otherwise also, this is a technical, very technical issues are involved, man, which we are not expert in. It should be left to the wisdom of the technical persons. On that, my lord, I will just relying on this 2023 SSC online SC 12 to 23.
Citation.
23 SSC online 1223, my lord. Here also, my lord, just one paragraph, my lord. I'm extremely sorry that I brought just one copy, my lord.
Is para?
35, my lord. Para 35, my lord. It is settled law that in contracts involving complex technical issues, the court should exercise restraint in exercising the powers of judicial review, even if a party to the contract is state within the meaning of Article 12 of the Constitution, and as such is amenable to the jurisdiction of the High Court, or the Supreme Court. The court should not readily interfere in commercial or contractual matters. This principle has been reiterated in the recent judgment of this court. J.B. Pardiwala Justice, speaking for the bench in Tata Motors, so and so. This court, being the guardian of fundamental rights, is duty bound to interfere when there is arbitrariness, irrationality, malafide, and bias. However, this court has cautioned time and again that courts should exercise a lot of restraint while exercising their powers of judicial review in contractual or commercial matters. This court is normally loath to interfere in contractual matters unless a clear-cut case of arbitrariness or malafide or bias or irrationality is made out. One must remember that today many public sector undertakings compete with the private sectors. The contracts entered into between private parties are not subject to scrutiny under the jurisdiction. No doubt the bodies which are stated within the meaning of the Article 12 of the Constitution are bound to act fairly and are amenable to the writ jurisdiction of the superior courts. But this discretionary power must be exercised with a great deal of restraint and caution. The courts must realize their limitations and the havoc which needless interference in commercial matters can cause. In contracts involving technical issues, the court should be even more reluctant because most of us in judges' robes do not have the necessary expertise to adjudicate upon technical issues beyond our domain. The court should not use a magnifying glass while scanning the tenders and make every small mistake appear like a big blunder. In fact, the courts must give fair play in the joints to the government and public sector undertakings in matters of contracts. Courts must also not interfere where such interference will cause unnecessary loss to the public exchequer. Number 6, my lord, para 36, my lord. The court ought to defer to the discretion of the tender inviting authority, which by reason of having authored the tender documents is best placed to interpret its terms. The court ought not to sit as courts of appeal, but review the decision-making process and examine arbitrariness and or malafide, if any.
But we're not
So-
dealing with complex technical issues.
My lord, we
We're
are,
not
my
dealing
lord,
with complex technical issues.
whether, my lord, that workability of the road, the rate as the state has said is not workable. And the interpretation of the clause 20.4.3.2, my lord. These are issues, my lord, we do not have expertise in, my lord. But the literal reading of the clause, it says over the justified.
According to you, it's not applicable.
It's not applicable.
Then, but the decision appears to be on the basis taking into account of these clauses.
No, my lord, it says,
Hmm.
yes, my lord, it says it's below the justified rate, my lord. Below the justified, and the variation up to 5% of the justified rate would be ignored when it is over the justified rate.
Whereas the learned single judge has wrongly interpreted.
That is my, respectfully, my lord,
They're
that is,
saying that it is within the variation of 5%,
that, my lord.
which is not the case here. It was a case of below the justified rate,
Yes,
not within the variation.
not within the variation, and the rate is
That
not,
below, not that's
yes, ma'am,
not the two, not above.
not above,
In the present case, below.
my lord.
Below the justified.
Below the justified rate, and the department has worked out the rate, and it says it's not workable rate, man. That is the case. And other than the finding that the 10% is the rate of the writ petitioner is 10% below the justified rate, man. That is nobody's case, man. On this finding, man. So I say, my lord, that learned single judge, my lord, with due respect, he has erred, my lord, and this judgment and order of 9/1/2026, it requires interference, my
9-1.
lord. Hearing was done on 3/11, my lord, and sadly, my lord, my submissions have not been recorded. So,
What is the status now?
status, my lord, that what happened, my lord, when the writ petition was moved, my lord, on that day, the judgment was not, the order, interim order was not passed in the open court, my lord. But it was reserved, basically. Now, it was on 6th 6th of June, man, 2025. And On the same day, my lord, department also, my lord, issued the order, my lord, LOI, my lord. I have submitted my PG, everything, my lord. The order was, the interim order of 6/6/2025 was not to finalize the tender, my lord. But by that time, my lord, when the order was given, my lord, by that time, tender had already been finalized, my lord. And that order by which LOI was awarded to me, my lord, it was also not put to challenge, my lord, other than the grounds that has been raised by my brother is appearing for the state. The 6/6/2025, that order has never been put to challenge, although they are aware of it, my lord.
But there is a direction not to finalize.
There was direction not to finalize, my lord. But before that order was received, my lord, that already the tender was basically finalized, my lord. On 29/5, my lord, has seen the note also, my lord. The order itself, my lord, 29/5/2025, that order. By that time, the tender had,
Writ petition was filed on
writ petition was
Probably on 5th June, my lord.
5th of June, my lord.
May, June, yes.
Yes, 29/5, that order was already there, my lord, whereby my bid has been approved, my lord.
Hmm.
It was filed on
This,
5th of
bid of the petition was rejected.
rejected, my lord. Now, and that order was of as arguments advanced by my brother, that 29/5/2025 order, that was never put to challenge, man. And in the interim order also, though it says 6/6/2025, it was not given on 6/6/2025. It was reserved, my lord.
Have
And-
you brought on record all this,
My
your
lord.
affidavit,
Yes, my
when
lord.
it was finalized, when the LOI,
Yes,
My
my
lord,
lord.
yes, it is all there.
It is there. My lord.
LOI was given, all
Yes, ma'am.
issued and-
Yes, yes.
Everything is there.
Yes, yes.
And on the 6th, my lord, the LOI is given, my lord. That has also been brought in. By that time,
What
the
was
interim
their
order
reply?
was,
My
to
lord.
your affidavit.
My lord.
What was their reply? In your, to your affidavit,
To my affidavit.
state affidavit. Ah.
They would be the best person now, my lord.
Hmm.
the orders and
Actually,
everything, my lord.
To what I recall, 6/6/2025 was Friday, my lord. So the order was passed on Monday, my lord. So on Friday, on 6/6/2025, we have also issued the LOI, my lord.
Hmm.
The order was reserved, my lord. Order was passed on Monday, my lord.
That those orders were
Interim
also
order was passed on.
interim.
Yes, it was.
Interim order was not to finalize the tender, my lord. But by that time, tender had already been finalized, my lord. LOI issued. I already submitted the PG, everything.
You brought all these things with.
Yes,
in
ma'am.
your
Yes, yes, ma'am.
Yes, it is in the affidavit, my lord. It is a counter affidavit of the department, my lord. Everything, my lord. But they did not put that to challenge, never. My lord. Paragraph 8, my lord, of the counter affidavit, my lord. It is at my appeal page 147, para 8, my lord.
Hmm.
The state has brought everything on record, my lord. And this thing, my lord, here it is said about the order of the 29/5/2025, the order of the 6/6/2025, whereby I was given the work. Now, in affidavit reply, they have only said these are all matters of records, and they don't want to make any comment. Otherwise, it is a record, my lord, based on records only.
Yes. Even here, yeah. Yes.
May it please your lordships. Lordship, certain dates are important.
Hmm.
My lord, 29/4/2025 was the last date of submission of bids.
Hmm.
My lord, technical bids were to be opened and evaluated on 30th of April and financial bids on 1st of May.
Hmm.
My lord, as per their affidavit which they have filed, my lord, the justified analysis of the rates
Hmm.
was done on 11th of April 2025, page 180 to 181
Hmm.
of their affidavit. And justified rates were approved by the joint director on 21/4/2021, 25, my lord. It is at page 183. If my lord comes to page
Okay, the writ appeal 21.
in writ appeal 20, my lord, in the state's appeal.
Page?
183.
180?
83, my lord.
Yes.
This is the order of 21st April 2025. Justified rate is hereby approved at the rate of 7.31% below the BOQ amount put to tender in respect of CD Block Chetam Package 8 for procurement and supply, so and so. Now, my lord, the last date of submission of bids was 30th of April. My lord, I have prepared a table. So I have put as petitioner and respondent number 5. My lord. Yes, 1-4. The estimated cost, my lord, the spellings are a bit, it should be estimated cost and the amount and just, but anyway, my lord. The estimated cost is 536,45700. Justified rate is 491. Lordship sees the fourth and fifth columns. These are it's the same for everyone. Justified rate is 491,24886.96. Now my bid or the bid amounts are in the third column. My bid is 482,81,129.93, and that of the appellant in WA 21, it's 497,22,889.85. Now, Lordship will see the variation from the estimated cost and the justified rate. This is for better understanding. The second last and the last columns. My variation from the estimated cost is 10%, and from the justified rate, it's 2.69%. The variation of the appellant in the other writ petition, that's WA 21, it's 7.31% below the estimated cost and exactly same as the justified rate. With the other party, my lord, he's not involved, so therefore I would skip that. But what I am on, my lord, the justified rate of the other appellant is exactly the same, and this justified rate was finalized on 21st of April prior to the submission of the bids. Rest, Lordship knows as to how that exact same amount can be quoted. I do not have proof. In fact, this was my submission before the learned single judge as well. It is the very exact same amount.
Are you
Bias in law, my lord.
alleging bias?
Bias in law.
Any foul play or something?
I am alleging bias in law, my lord. I have not made them private respondents,
Then-
the others. But that is why, my lord. And this was the exact submission which I had made before the learned single.
Now, without providing them opportunity, we
Of course, I'm submitting,
cannot determine that.
my lord. Of course, I'm not alleging bias in fact. I'm alleging bias in law, my lord.
We cannot say that.
I do not have proof, my lord.
No.
I cannot allege.
We also equally cannot say that it was. How can he? I mean, submit the exact justified rate
My lord,
unless you prove that they were.
I cannot, my lord. I cannot prove that. And that is why, my lord, I am not making submission on.
It's also possible, is there? He may
Well,
quote
it's-
the exact rate also.
It's possible, my lord, but is it probable, my lord? That is the question I ask myself.
So now,
In any
now,
case, my
so
lord.
far as the learned single judge is concerned,
My lord,
he said the para 35,
my para 27 onwards.
27.
My-
What he said? He
My-
said it's within 5% variance.
Yes,
I think it's apparently appears to be not correct.
My lord, since
Because,
lordship is,
because this 20.4.3.2
my lord,
talks about the variation above the justified rate.
my lord. My
Right.
lord, here, if lordship takes up,
And your
loss,
case has been rejected because you have
it is above the justified,
not above. It's below the
Ah.
justified rate,
below the justified rate by
2.69.
2.69%.
And the respondent has quoted unless you.
Zero variation,
Ah,
my lord.
Then
That I cannot prove, my lord.
obviously.
That I cannot prove, but
It's not your case that you cannot, I mean, they cannot provide the justified rate,
my lord,
that you are not agreed.
my lord, my lord,
And most importantly,
my lord,
as they have submitted,
my lord,
when these things,
my lord,
LOI and all these orders are brought on record,
my lord.
you have choose not to challenge that also.
My lord, this LOI was issued, my lord,
Third by the, what do you call it? District committee.
my lord,
They have rejected your case.
my lord.
It was sent here for final or.
I'll come to that, my lord. The district committee, if
And
my,
the interference by the learned single judge
my lord,
apparently seems, it's a office note, which is the extract of the decision of the
my lord,
district board,
My-
which you have not put to challenge.
my lord, my lord, there is a reason why, my lord.
Mm.
The reason, my lord, as on the date when this was moved, the writ petition, my lord, was filed on 4th of June, 2025. My learned brother, my lord, it was in, I have checked from the website, from the High Court's portal. It is filed on 4th of June.
Mm.
The order was passed on 6th of June. The LOI was issued on 6th of June. Now, in paragraph 8 of their affidavit, what the director says is that he was unaware of the filing of the writ petition, which it is unbelievable, my lord. Because, my lord, the copy was served on the Learned Standing Council.
He was ill or
No, my lord, on the 4th of on 6th of June, he was there. My lord, the unfortunate event happened thereafter, my lord. On 6th of June, the Learned Standing Council was representing the department. The director has made submissions against, I'm sorry to say, against my learned friend, when he says that he was unaware. My lord, will a standing council appear without taking instructions? This is, my lord, unbelievable, my lord. The director, I'm sorry to say, my lord, has not put correct words in the affidavit. He says he was unaware. In para 8, if I may read, my lord, para 8 of their affidavit, this is,
okay.
my lord,
What does it have a bearing?
my lord,
Does it have any bearing?
my lord, the LOI was issued on 6th of June, but prior to that, on 6th of June, the interim order was issued, passed by this honorable court, saying that the tender will not be finalized. If the tender is not if there is an order, this interim, this LOI issued is non-honest, my lord. They could not have, because lordships were examining in the single bench, lordships in this High Court was examining the correctness of the rejection of my bid. Faced with that, they issue it, my lord, overreaching lordship's directions. So this LOI could not have been issued when there is a direction by this court not to finalize the tender. Issuance of LOI is finalization of tender. So therefore, my lord, this LOI is non-est.
No, in fact, you have not challenged the rejection. You have
The rejection I have, my lord. Those
what is saying that it's a file noting.
my
This is
lord,
the extract of that order.
my
In
lord,
fact, order was not challenged.
my lord, the file noting culminated in the LOI. This order, my lord, if lordship reads, they say that there is some mistake, and therefore, at page 149, 194 and 95, there are certain differences from what is extracted in the file note, which I'm sorry to say, my lord, is incorrect. It's the exact same figure which is there in page 139 as well as page 194.
Obviously, there could not be any different figures.
Yes, my lord. So therefore, their submission that it was wrong is incorrect. The wrong which they say in the affidavit pertains to some other blocks, not Chetam CD block package 8. In package 8, it is the same noting which is there, and this file noting, my lord, extracts that particular at page 194, which is reflected in the file noting as well as in page 194. It is not different.
Anyway, on merit, if
Yes.
the respondent, I mean the appellant
My lord,
in this thing, the Triple R Enterprises.
My lord.
If he has quoted the exact justified rate.
My lord, on that, I'll make my submissions, my lord. This of the CPWD manual, taken the photocopies, my lord, of the CPWD, and in the other writ appeal, it is annexed,
Yes,
my lord.
we next see it.
Yes, my lord. My lord may see clause 20.4.3.2.
Hmm.
My lord, my learned friend is stressing on the wrong word.
Which
Uh,
one?
This will be, the page numbers are down below, page 140 in the footer, my lord.
Acceptance of tenders.
At justified rates with allowable variation. That is the heading, my lord. With allowable variations.
Hmm.
What is variation, my lord? Vary. I understand. What is vary? Vary is neither plus nor minus only. It is on both sides, like the pendulum. The pendulum will swing once towards the left, once towards the right. That is the variation. Variation does not mean only positive. Here, what does it say? Apropos provisions under para 20.4.3, variations up to 5% over the justified rate. My learned friend is stressing on the word over the justified rate. Here, it does not mean above the justified rate. It means variation over. Otherwise, it would have said any rates above 5% of the justified rate may be ignored. It does not say so. It says variation over 5%. Variation does not mean only positive. Variation means positive as well as negative. And this has been accepted by the departments in the government of Arunachal Pradesh. I have annexed that particular document. There was some confusion, but they have accepted it. I have annexed it in the writ petition, my lord. My lord, this is at, sorry, my lord. I'm sorry, my lord, just. This was the variation, the minutes of the meeting. Writ petition. I'm sorry, my lord, I'm just.
See,
My lord.
assuming that your suppose accepting your
My lord,
submission
my lord,
that the variation of 5% is not only above,
My
it
lord.
could be below also.
my lord, my lord, my lord,
Right.
my lord.
What is the variation?
Mine is minus 2.69. It
Huh?
is within 5%. It is within 5%.
Then what about this?
My lord,
What about the appellant?
appellant is 0%. 0%. What the CPWD manual says, my lord, is variation up to 5% over the justified rates.
Maybe ignored.
May be ignored. Mine is within this, my lord. Minus 2.69, which is within 5%.
That has been
So-
considered, but then he has a better, this thing, feasibility and other thing.
My lord,
He has quoted the exact rate.
Exactly.
Therefore, your rejection is that you have caught
below,
below,
my lord, my lord,
below justified rate.
My-
Therefore, you could not be.
my lord, will the state lose?
So if he has a different, if other person,
My lord,
your competitor,
my lord,
huh?
my lord.
If they have a better, they have quoted a better price,
They have quoted a
which is
higher
exactly what is the, the justified rate.
price. My lord, my lord. My lord, they have quoted a higher price. The state is going to lose. I have quoted a lesser price.
Then
Now, will the
why then what's the meaning of having a justified rate?
That is what, my lord. That is why I am on. If there is a justified rate and I quote below the justified rate,
Yeah.
the state is going to gain. And about the quality of the materials, my lord, at page 54 and 61, I have the special conditions and the specifications are mentioned. I cannot give materials which will not be accepted by them. My lord, if my lord reads page 54, special conditions. Page 54. I'll come to it. Page 54, clause 3, materials. The contractor shall arrange all materials other than those stipulated in clause B of the tender document. Engineer or in charge or his authorized subordinates reserve the right to reject any material, including forest produce, aggregates, sand, etc., if not conforming to the specification, and the contractor shall have to remove and replace the consignment at his own risk and cost. Non-compliance of this part of the contractor shall be treated as breach of contract and may lead to termination of the contract. Now, materials stipulated in Schedule B, Lordship may ignore that. Then clause 5, quality control. The engineer in charge shall check the contractor's work and notify the contractor of any defect that are found. Such checking shall not affect the contractor's responsibilities. The rest, my lord, the engineer in charge may instruct the contractor to carry out a test not specified in the specification to ascertain the status of the defect, and if the report indicates existence of such defects, the contractor shall rectify the defect at his own risk and cost as governed by clause 17 and also pay the fees for such tests, so and so. Now, Lordship may come to page 61. Clause 5 of the specifications. All materials used in the work shall comply with the requirements of engineer in charge and shall pass all test analysis required by him as per the particular specifications as applicable or such recognized specifications as acceptable to the engineer in charge. So I cannot give substandard materials. Whatever materials, it has to be acceptable to them, otherwise they will reject. Now I quote the material, I give the same materials at a lesser price, but they want to give it to a contractor quoting a higher price. Who is going to lose, my lord? It is ultimately the state who is going to lose. And here, my lord, the submission of my learned friend that this justified rate variation is allowable only above 5%. Only above 5%. Yes, I've got it. My lord, at page 152, it is a minutes of the meeting. It is their document, of course, pertaining to PWD, but it is the same CPWD conditions. Page 152.
Yes.
A meeting was held on 27/10/2017 at so-and-so in the conference hall of Commissioner PWD regarding acceptance and award of tender works and APPWD. In the meeting, the proposal 20.4.3.2 of CPWD Works Manual 2014 was discussed in detail, and it was unanimously decided that the lowest tenderer with a variation of 5% plus or minus over the justified rate shall be considered for award of works as per the said clause. So variation, my lord, I agree with my learned friend that a literal interpretation of the word vary has to be given. I agree. The literal interpretation is vary does not mean one way. Vary means like a pendulum, both sides. This is accepted by the PWD department that it is to be plus or minus. The government cannot speak in two voices, one for PWD, one for RD. The government has to speak in one voice. For PWD only plus, both plus minus, for RD only plus. That, my lord knows, the government has to speak in one voice. A catena of decisions on that. This decision is there. So my learned friend's submission that it is variation is only above is incorrect. my lord.
Suppose if it is to be considered, but then if he has a better, there is some other tenderer who has a better, this thing,
I have the
which is
my lord.
Better than your, including the feasibility and all.
Mine is better, my lord.
If the other, yours is better in the sense you have quoted, you have a lesser
price. Better for the state because of the same material.
According to, but they found that since he has quoted the other one has quoted this exactly within the thing, same as that of the.
My lord.
That justified that they found that it is better. Better for them. That's why he's been selected.
My lord. But that goes.
The case that your only case is that, see, that's why I said,
my lord.
I have indicated you. Let us assume that your submission is correct.
My lord.
So far as the variation is concerned.
My lord.
So admittedly, you have quoted 2.9.
2.6.
Assume that it could have been considered.
My lord.
But they have decided otherwise.
My lord,
because your case has been rejected because though you have quoted lesser price.
My lord. My lord.
Huh?
My lord.
But then you are found to be 2.9
My,
below the justified rate, whereas the other
my,
tenderer, they have
my,
quoted exactly justified rate.
my lord.
So according to them, it's
My lord, this is changing the rules of the game because the tender conditions specify that 20.4.3 have to be followed.
Ah.
The tender conditions, my lord, clause 23, my lord, clause 20.
You're saying that they could not have fixed the justified rate.
They can have fixed the justified rate.
Then,
But clause 20 of the additional conditions,
Hmm.
they say that clause 20.4.3 has to be followed.
hmm,
In the NIT, it is there. So now, my lord, after the NIT is floated, they cannot change the rules, my lord.
no, where does it say that, then in that case, where does it say
My lord,
that even if a person or tenderer or
My-
bidder
my lord,
quoted within the variation of 5%
my lord,
and having the, lesser price
my lord,
should be given the tender.
my lord,
It doesn't say so.
my lord, clause,
May be ignored,
it may be ignored.
right?
And read with that, the CVC guidelines, my lord, that it has to be awarded to the lowest bidder. My lord, not only that,
But Supreme Court said the
yes, in a
looking for
given
height
case,
is not a
my lord, in a given case, yes.
fixed criteria.
But my lord, this is changing the rules of the game by them. My lord, if my lord comes to page 58,
Let us not bring anything which is not relevant. It's not.
my lord, of course, my lord, page 58, if my lord,
You might say that they have not followed or they have
they've
not
violated.
properly
Yes,
complied with the requirement of that CPW manual.
my lord, yes, my lord,
There's no question
I'm
of
grateful, my
changing
lord.
the rule of the game.
I'm grateful on that, my lord,
Hmm.
that this clause 20.4.3 is quoted in clause 20 as well as clause 23. My lord, at page 58, if my lord comes to 58 of the tender, it quotes the tender conditions of the additional conditions. Clause 20, my lord, page 58, clause 20, the tender shall be governed, my lord, by clause 4.3 of under section 20 of the CPWD Works Manual for reasonability and competitiveness of rates. Now, for reasonable rates and competitiveness of rates, clause 20.4.3 has to be followed. This is mandatory in the tender conditions. There, along with that, clause 25,
Yes.
my lord. As per CPWD manual and SOP 5.5 of the Works Manual 23, with additional security. If, my lord, this is a longish one, but with additional security, if it is below the estimated cost, additional performance security is to be taken.
Other one is quoting the better. Which is exactly justified. Otherwise, which is having justified. It's not different that in cases where the means found to be below 2.9% below the justified. Even better quoted is still the lowest price. Yeah. Doesn't seem to cover. Maybe ignore. But it doesn't say that we should do with it. Having the lowest, quoted the lowest cost. Why is he saying this since they have quoted the one that's right? Since why within the pharmacy, the 5% rules, I should have been given the acceptable that cannot be when you assuming that it should be ignored. But then provided if someone other than that doesn't quoted, maybe we know that in the to be sure. Okay, the other thing is properly. Jangan. Ini angin. Tenan. Yes,
My lord, what I would be on, my lord,
let us finish
my lord,
within 5 minutes.
my lord, here, what I would be on, my lord, is that they cannot move away from the tender conditions. Dr. Associates Lordship is aware of. Dr. Associates, my lord, para 4, 5, and 6.
They have not moved away.
My lord, exactly, my lord.
That has been followed.
My lord, they have, my lord, they have to ignore.
You are,
Yes.
ignore doesn't mean that you will be given just
My-
because you have quoted the lowest rate.
My lord,
It cannot be.
my lord, what is the reason for that?
See,
The reason, my,
Supreme also said that
Yes.
the highest or lowest it cannot be a,
it can be ignored. Yes, my lord, they may not award it to the lowest.
yes.
But the decision-making process, that has to be
They
above
found
board.
in him better,
My lord, how?
that the exact justified rate. Otherwise, what's the meaning of having a justified rate?
Exactly, my lord. Exactly. Now, my lord will see how they arrived at this decision. My lord, page 139, which is the same figure as in the table my learned friend has relied on.
39.
139, that is their reason for rejecting me. Clause 7 is package 8, CD block Chetam. The remarks, that is approved at the rate of minus 7.31%, quoted minus 10%, rejected. Minus 10%, this is of estimated cost. They have not gone by justified rate. They have only mentioned approved, but they do not bring in the variation. Now, L2, and I have put in as L1 here in this table. They have rejected me. L1 is rejected. L2, they have put it as the responsive firm at minus 7.31% and quoted as minus 7.31%. But 7.31 of the estimated cost, they do not follow 20.4.3 here, my lord. 20.4.3 has to be on justified rate, not on estimated cost. And the reasons which they have given is only on estimated cost. Nowhere they say about justified rate. Just to, my lord, misrepresent before this honorable court, if I may use the term, my lord, they put in minus 10% of the estimated cost. They do not bring in to show that I have quoted much below, but it is actually minus 2.69 below justified, which is an allowable variation. And when the tender conditions provide for allowable variation, my lord, Dr. Associates is clear, my lord, it's a fair dealing, my lord.
No,
And-
no, see,
My lord,
this is all equally. Equal consideration is given to all of them. See,
my lord,
it's not the case that your case has been rejected on the quoted,
my lord,
the estimated cost,
my lord.
and others have been on justified rate. It's not that. See, look at this.
I have seen that, my lord. But my lord, here,
Approved rate is,
minus
they have not
7.31,
clearly said so, but then minus 0.31
my lord.
for all.
My lord,
It's
yes,
same.
yes, my
Quoted
lord,
10% rejected.
my lord.
It may be 10% below the
Estimated,
estimate cost.
my lord.
Same thing.
But my lord, then going by this, they have not followed clause 20.4.3 or section or clause 20 of the NIT, my lord. Clause 20 of the NIT, my lord, goes for, my lord, gives the leeway for allowable variation, which is there in Dr. Associates. In Dr. Associates, it has to be open, transparent, and fair. This has been done away with, my lord.
It's okay. It's not the case that you have been. Your case is that you are the lowest one. Since
My-
there is a variation, you
My
should
lord.
have been awarded.
My lord,
What they've done is
my lord,
they found that the appellant to be most suitable and feasible on
But
the
why-
basis of feasibility,
my lord,
who has quoted the exact
justified rate.
justified rate. Can't help it.
But the reason,
Otherwise, what's the reason? What's the meaning of having a justified rate?
exactly, my lord, the reason is this is the rate and certain amount above or below is acceptable to protect the state exchequer. My lord, in this case, my lord, going by the justified rate, what is best for the state exchequer, and if my rate is not workable, then I should not be given. They say it is an approved rate. But is my rate not workable? How is that to be determined, my lord? That is to be determined by 20.4.3, which says plus minus 5. That is to be ignored. That is the best possible, my lord, reason for rejecting or finding rates which are unworkable. 20.4.3, which they quote in the NIT. Going below that plus minus 5%, you have to reject even though he is L1. But within plus minus 5%, the L1 is to be awarded. L1 can be rejected. Yes, my lord, I'm clear on that. The Supreme Court has time and again said it is not necessary to accept L1. But how is to be determined, my lord, whether that L1 is to be accepted or not accepted? It is to be by an open, transparent, and fair process. That they have quoted the reason for rejecting L1 will be in clause 20 of the additional conditions. If you quote below this, you are gone, or above this, you are gone. Between this play in the joints, you have to be accepted. Otherwise, this is a decision, my lord, which is not bound by reason. It is arbitrary, it's clear on the face of it, my lord.
Obviously, you will say so.
My lord, naturally, my lord, naturally. Because what is to be between the lowest price base for the state exchequer is, my lord, to be determined under clause 20.4.3. Below that, L1 has to be rejected. Otherwise, there is no need for having quoted clause 20.4.3 in clause 20 of the additional conditions, as well as clause 25. So therefore, my lord, L1 has to be accepted. My lord, if it is within the limits, if it is beyond the limits, it is an acceptance of L1 is there, that would be arbitrary. On the other way, my lord, on the other hand, if it is within the limits, rejection of L1 is arbitrary. What is that limit? Plus minus 5 of justified. And they have very cleverly put in minus 10 of the estimated cost. And the decisions relied on by my learned friend, my lord.
Dr. Associates Para?
Para 4, 5, and 6, my lord.
Oh.
If given the copies. Yes. My lord, may I read, my lord? My lord, para 4, 5, and 6 of Dr. Associates is clear, and Lordship knows. My lord, there are other decisions as well, my lord. Kimberley Club, I have, shall I give the copies, my lord? My lord, 2025 INSC 1276, Kimberley Club, my lord. Para 13.
You
And-
did that.
My lord, Kimberley.
There are 13.
Para 13.
This terms
It-
must be clear. and
It is right that terms of NIT must be clear and unambiguous. If the first respondent intended that Haysiyat Praman Patra must be issued by the district magistrate alone, it ought to have specified so in the NIT conditions. Then para 18. For the aforementioned reasons, we are of the opinion that rejections of the applicant's technical bid on the ground that appellant certificate was not issued by the district magistrate is dehors the terms and liable to be quashed. My lord, this rejection was dehors the NIT terms. In my case, my rejection is beyond the NIT terms. Clause 20 of the additional conditions, my lord. Clause 20 says 20.4.3 has to be followed. In my case, they have not followed 20.4.3.
So according to you, the state has not followed the 20.4.3.
Yes, my lord, they have not followed. Because 20.4.3 is mandatory to be followed in determining who is to be accepted.
How it has to be, how this justified rate and this variation is to be reconciled?
My lord, variation is on the just 20.4.3, my lord, a plain reading of that.
Then-
My lord, it shows, what is 20.4.3 before that, my lord? 20.4.3 is justification of tenders. 20.4.3.1.
20.4, reasonable.
The main heading, I'm grateful to my learned friend, my lord. The main heading is reasonability and competitiveness of rates. The tender accepting authority shall satisfy himself about the reasonability of rates. And in the first page of my photocopy, my lord. Acceptance or before acceptance of tender, reasonability of rates shall primarily be assessed on the basis of justified rates. The mode of preparation of justified rates is detailed in following para 20.4.3.1. Permissible variation over the justified rates are given in para 20.4.3.2. So first of all, justified rates are to be determined. And thereafter, what is permitted to be varied? The fair play between the joints. That is 20.4.3.2. That is plus minus 5.
So it doesn't indicate that once you quoted within the variation of 5% and it has to be ignored and the lowest should be given. It doesn't say so.
My lord, a reading of
Simply says that
My-
if a bidder quotes a variation within the 5% variation,
my lord, is to be ignored.
ignore.
Yes, my lord. My lord, what is the meaning of that? Why is it put? It is put because what is to be ignored? What is the reasonable and competitive rate? The reasonable and competitive rate, my lord, within plus minus 5 is the acceptable limit. The fair play between the joints and the variation, given, my lord, indicated in Dr. Associates.
No, that's why I'm saying how you reconcile with this the
Yes.
justification of 5% and justified rate. It has to be considered together.
Yes, my lord. It needs to be considered.
5% is a variation of justified rate.
Yes, my lord.
If somebody quotes a better price,
Yes, my
not
lord.
necessarily lowest or highest,
My lord.
if it's considered
My
lower,
lord.
then what's wrong there
My lord.
in it?
My lord, what is, my lord, the person quoting the exact justified rate, if he is awarded, is it not, my lord, detrimental to the state exchequer? The state is paying more.
You have,
And the reason, my lord,
first this thing 20.4 you have read.
yes, my lord, 20 point.
Reasonability and competitiveness of the rates.
Yes, my lord. Yes, my lord. The justification statement shall be prepared for checking all reasonability of rates. The method considered of the detailed analysis of rates by taking market rates of labor, materials, cartridge, etc. The method of analyzing item is the same given in the standard CPWD analysis of rates. The major item on the whole costing at least 10% of the estimated cost put to tender are analyzed to work out the justified percentage of its basis. The items.
Done.
Yes, my lord. That was done, and they have arrived at minus 7.31%. Now, my lord, thereafter, if 20.4.3.2, which is quoted in that NIT, should that be ignored or not, my lord?
No.
It should.
Ignored in the sense, it's not that you will be outrightly rejected.
Yes, I have
If
to be
they
considered,
found that on the basis of the justified rate, after analyzing all your prices,
my lord.
if they found that the tenderer has quoted the most
My lord.
reasonableness, I mean, within the justified rate,
My lord.
better than
Yes.
others, though they may fall within the variation of 5%. What's
Right.
wrong in it?
There is nothing wrong in that. There is nothing wrong. Lordship is correct. But, my lord, what are the materials to be supplied? It is the exact same materials which are to be supplied. Someone quotes 100 rupees. I quote 95 rupees. 100 rupees is the justified rate. I quote 95 rupees for the same materials.
Sir, I think we cannot go into that because
My lord, that is for the evaluation committee to decide. I understand.
they have decided.
They have decided on the basis of arbitrariness, my lord. ignoring 20.4.3. That is my submission, my lord. Because, my lord, 20.4.3 has to be followed. Because, my lord, the best price at which the state procures its materials, that is to be the consideration. And of course, I understand the quality has to be determined. The other decisions which Lordship has indicated, that is the best available materials at the best quality. Now here it is the same material at a higher price they are procuring. Is it not arbitrary, my lord?
This is what you are saying.
My lord, that is why I have read, my lord, my lord, clause 3 and 5 of the special conditions and clause 5 of the specifications. It is the same materials which are to be procured by them. And if I'm offering it at a lower price, if within the allowable variation as per 20.4.3.2, my lord, if they reject it within the allowable variation, that is arbitrary. Beyond it, if they reject, they are right. But it is within that plus minus 5, and therefore the rejection of my bid is arbitrary.
Now, whatever the judgment of a single judge,
My lord, the judgment is right, my lord, paragraphs 27 onwards, my lord. And the state's appeal, my lord, that was never pleaded, as Lordship has rightly pointed out. My lord, from page 220 of the state's appeal, para 25 onwards, from 27 is the consideration. 27, my lord, upon page 220, Lordship is on. Upon giving my consideration to the entire matter in the context of applicable guidelines of CPWD manual and the additional conditions of the NIT, I come to the considered opinion that the respondent authorities made an error in holding that the bid of the petitioner was 10% below the justified rate. Whereas, in fact, it was 2.9% below the justified rate and within the permissible variation bracket of 5% of the terms of clause 20.
no, this is also not correct.
My lord,
It said that it's below 10% below the justified rate.
my lord, they
Record
say,
doesn't indicate.
my lord, it says 10% below the estimated cost. My lord, below page
below the
139.
Justified rate.
Yes, my lord. It does not say below justified rate, but they say
Then
approved
how
rate.
this can be recorded?
My lord, that was the reason.
In holding that the bid of the petitioner 10% below the justified rate, it doesn't say so.
It doesn't say, it says
It doesn't
10%
say
below the estimated cost.
Huh?
Below the estimated cost. But below, what is the range between, within the allowable variation of justified rate? That is 5%, which is 2.9%.
In fact, it was 2.9% below the justified.
Within the permissible variation bracket of 5% in terms of clause 20.4.2 of the CPWD Works Manual, 2014. Further, I also find force in this contention of the petitioner firm made through its affidavit in reply that the respondent authorities perhaps erred in holding the view that the firm whose bid value is equal to justified rate percentage only has to be accepted. If the tender process, the petitioner firm was the L1 lowest bidder in financial terms.
Firm whose bid value is equal to the justified rate person only has to be accepted.
In the tender process, the petitioner firm was the L1 lowest bidder in financial terms, and its bid value of 482 so-and-so was approximately 2.9% below justified rate. And in terms of the applicable guidelines of the CPWD manual, within the permissible range. The bid of the petitioner was thus within the permissible variation range in terms of the guidelines. Hence, the respondent authorities were obligated in law and in terms of the tender conditions to accept the bid of the petitioner firm rather than that of the respondent number 5. It is well settled that evaluation of tender involves certain technical and financial expertise as well, and the courts in exercise of judicial review do not and should not easily substitute its view for the views of the authorities who might be having technical expertise. However, in exercise of such judicial review, if examination of the decision-making process and its legal dimensions reveals errors and arbitrariness, the same is required to be interfered with in exercise of writ jurisdiction. Otherwise, the same would be violative of Article 14 of the Constitution of India. Consequently, the writ petition is allowed with the following directions.
Record balance says so that, indicate that, say that 10% below the justified rate.
My lord, page 139, the reason for rejection is 10% below.
Is it said
It does not say 10%,
Below the justified rate.
my lord.
Doesn't say so.
My lord, it says, if I may read once again, my lord, approved minus 7.31, quoted minus 10%, rejected. But the rejection has to be, my lord, within the justified rate, not the estimated cost. My lord, the department itself has not clearly mentioned whether it is justified rate or estimated cost. It is from a reading that we find that it is justified rate and estimated cost. It doesn't say whether it is justified rate or estimated cost.
Page 187, madam. The
Yes, I will come
evaluation.
into that.
187.
187. If I may read 187.
Hmm.
The financial bid was opened on 1/5/2025 at so-and-so and evaluated. Number one, RRR Enterprise quoted a bid price of rupees so-and-so, which is less by minus 7.31% than the tender cost. Messrs. Salo Enterprise has quoted a bid price of so-and-so, which is less by minus 7.23% than the tender cost. And LY Enterprise has quoted a bid price of so-and-so, which is less by 10% of the tender cost. However, the justified rate of Chetam CD block is approved at 7.3% below the BOQ amount.
He said tender cost,
Tender cost, yes, the estimated cost.
but learned single judge has recorded that less than minus 10%
My lord,
of the justified rate.
my lord,
But it clearly says that
my lord,
tender cost.
my lord. But the variation is to be on the justified cost, on the justified rate, not on the tender cost, as per clause 20 of the edition.
So what I'm
My-
we're indicating you is that
I understand, my
it's
lord.
been, it's not a.
I understand, my lord. That might have been a typographical error, my lord. Might have been a typographical, because that is the same figure, but might have been a typographical error.
That's all.
My lord.
Lord, I'll just take 1 minute, madam. That, I'm still on that variation part, my lord. Because, my lord, that CPWD manual doesn't say variations. If it was only variations, then I would agree with the arguments put forward by my brother, man. But it says variations up to 5% over the justified rate may be ignored, man. It doesn't say variations up to 5% of the justified rate or the variations within 5% of the justified rate. There is a specific word over, my lord. That has to be seen. And secondly, it says may be ignored, my lord. It doesn't say that lowest rate. One more thing, my lord, that if your lordship would come to page 222, my lord. It's a direction that has been issued, my lord, whereby the order dated 2/5/2025 has been set aside, my lord. But records reveal, my lord, there is no order as such, my lord, of 2/5/2025, my lord. 222, page 222, my lord. The operative portion of the judgment, my lord.
Okay.
2/5/2025.
Hmm.
My lord has gone through the record, my lord. The order by which the bid was rejected was 29/5/2025.
Hmm.
The petition was filed on 4/6/2026. But 29/5 order by which the bid was rejected, that was never put to challenge, my lord. And there is no order as such, my lord, 2/5/2025, my lord. The order by which the bid was rejected, a bid of the petitioner was rejected is 29/5/2025. They have never put that to challenge, my lord. And regarding this 20.4.3, my lord, of course, this is by a single judge, my lord. There is no finding as such, but this honorable court has also said the last paragraph, my lord, 18 and 19. This honorable court has also said we do not have any exercise as such in these issues. The last page, my lord, the paragraph 18 and 19.
18.
18 and 19, yes, my lord. Coming as regards this, my lord. The interpretation of the department has to be, my lord, accepted, not what the petitioner wants. because it specifically says over, and it may be ignored. It is up to the discretion of the department. That's all, ma'am.
One of the I rely on some of the judgments that briefly indicate the paragraph. On the submissions of my learned friend about the decision-making process, the file notings. Mine.
You may get one. Noting.
One of the decision relied on by my learned friend,
Shanti Sports.
Shanti Sports. My lord, that was on the basis of, my lord, acquisition of a plot of land which was sought to be overturned.
Hmm.
That was in the context of that land acquisition for a building. My lord, paragraphs 2 to 15
Hmm.
of Shanti Sports Club delineate the facts, which is not applicable in this case.
Hmm.
The few decisions, my lord. My lord, one is NP Power Management Company Limited, Jabalpur, my lord, 2023 SCC 70003, my lord. The relevant paragraphs, my lord, would be, I'll note down in a page and.
Yes.
my lord, if- MP Sports Club, then Andhra Pradesh State Financial Corporation versus Gar Rolling Mills, 1994 2SC, page 647. Maharashtra versus Prabhu.
Why so much of the judgment?
Man, I'll give only
Just
this.
two, three.
Man,
At best.
in a page, I'll write down the paragraphs. Man,
Deeply aware.
deeply.
Just right. Heard Mr.
BP Chairman,
B. Picha,
Standing Council RD.
standing counsel, are the for appellant in WA 20 of 2026.
Yes.
And Mr. D. Soki, learned counsel for appellant in WA 21 of 2026. And also heard Mr. P. D. Nair, learned counsel for respondent one.
Respondent one, in both.
In both the appeals.
In my lord, WA 21, my lord, is the respondent of 5.
Oh, yes.
Okay.
Sorry, I'm correct.
Respondent number 1 in WA
20.
20 and respondent number 5 in and 5 in 2021 of 2026. Hearing concluded. Judgment. Yes. Ah. Yes. 18. Yes. Yes.
My lord, this matter become instructors, my lord, so I may be allowed to withdraw.
Okay.
Matter may be closed, my lord.
Mr.
18.
M. Doji, learned counsel for the petitioner, submits that writ petition has become in process, not writ, matter has become in process. Who else are appearing? Respondent,
Yes, Sir Lordship, I'm for the state.
Ms. MSPPP Pang, learned state council is present. Accordingly, writ petition is still closed as having been become in process.
Lordship. May I, Your Lordship?
Hmm.
Lordship, I beg to mention item number 6, Your Lordship.
Hmm.
Here, we have yet to receive our instruction.
Hmm.
So, Your Lordship, this matter to be listed next week, Your Lordship, on Monday.
Why Monday?
No, actually, I have not received the instruction, Your Lordship.
Fixed after 2 weeks. On the prayer of MS, the P. Pang, London State Council, list this matter after 2 weeks for instruction. so as to enable her to obtain instruction. Yes.
And also, Your Lordship, item number, Your Lordship, 20 and 21, Your Lordship.
Hmm.
Here also, Your Lordship, we have not received instruction, Your Lordship.
2021, huh?
Yes, Your Lordship, we
Same
need
order.
some more time, Your Lordship.
Same order.
ठीक, obliged, Your Lordship. Okay. And also item 24, Your Lordship.
Hmm.
In this matter, Your Lordship, we have received a parabolic reply for respondent number 5 and 6. And other respondent, we are yet to receive, Your Lordship. At least 2 weeks time may be given, Your
Same
Lordship.
order, same order.
Here I have.
Obliged, Your Lordship.
Ah. You record his name also?
I have put a petition.
Aye.
Obliged, Your Lordship.
Mano, Kalal Pal. Ali. May I please, Lordship. Lordship, I beg to mention item number 19, Lordship. Review petition.
Ah.
Here IA is for, Lordship, there is a delay of 111 days.
90,
Yes,
19, yes.
19.
Ah,
But the service could not be completed. On last occasion, we have taken fresh steps,
ah.
but yet not completed. So matter, we need to wait for some time and matter may be listed after.
You want to take fresh steps?
Fresh steps already taken, Lordship.
When did you take?
It was, Lordship, on 23/6/25.
6/25. You take fresh step again?
Yes, Lordship.
It is submitted by Mr. K. Lowland Council for the applicant that although steps was taken on 23/6/2025,
Yes, Lordship.
there's no
One
report
number, right.
as regard the service.
Okay.
Therefore, he pressed for
Nahima bhai.
a week's time to take fresh steps for service of notice upon respondent.
Two.
Respondent number 2.
One is already represent.
Mr. So-and-so for appeals for respondent number 1.
Yes, you are.
Opposite party, respondent number 1.
Deeply
What's the
obliged.
matter after
After 3 weeks,
4 weeks?
4 weeks.
May I please, Your Lordship? Lordship, I beg to mention one unlisted matter for withdrawal, WPC.
Withdrawal?
Yes.
Okay.
My Lordship, I beg to mention item number 4. Lordship, this matter may be taken off on 25th of this month
Why?
with the consent from the respondent, Lordship. So I have a personal difficulty today, Lordship.
Why fix that?
Lordship, in fact, this is a 2023 matter.
Pleadings are complete.
Yes, Lordship, pleadings are complete. Pleadings complete, Lordship.
On the prayer, Mr. Aringo, non-council for the list this matter after list this matter on
25th of this month, Lordship.
25/02/2026.
Lordship, interim is there, interim account.
Country more than past earlier shall continue.
Deeply obliged.
May I, Your Lordship? Your Lordship, item number 8, Your Lordship. With the consent of the petitioner side, Your Lordship, may it be fixed on 10th of March, Your Lordship.
And on the prayer, Mr. J. Ridam,
Why Ram?
sorry, Y. Ridam, Learned Council. And as consented by Learned Council for the petitioner, list this matter on 10/03/2026.
Obliged.
May I, Your Lordship? Your Lordship, I beg to mention item number 22 and 23. I appear on behalf of N. Tajay for the petitioner in item number 23 and in respondent for item number 22 seeking for adjournment and your
Have you taken consent?
yes, Your
Okay,
Lordship.
on the consent of Learned Council for the
Lordship, fixed date may be given. Your Lordship may listed this matter after 3 weeks.
applicant, Learned Council, Mr.
M. Marde.
Learned Council M. Marde.
I appear-
on behalf of Mr. L. Taj, Learned Council for the respondents number 4. In IA.
Yes.
IA respondent number 4.
Yes.
Opposite party number 4 and the petitioner, let this matter be listed on
Lordship, a fixed date may be given.
when?
5th of March.
5th of March.
In IA. For the IA, because I'm the petitioner applicant in the IA. 5th of March. And Your Lordship, regarding item number 23,
Hmm.
Your Lordship may listed this
This
matter
should be
after.
listed together. IA 15. That was 5th of March.
Yes.
Hmm.
Much obliged.
My lord, I'm mentioning item number 15 and 16.
Hmm.
I may be allowed to withdraw the matter, both the matters upon instruction.
16.
Yes, Your Lordship.
Separate order, huh? On the prayer of Mr.
Ironia, Your Lordship.
P. Ronya, Land Council for the petitioner. No, Mr. P. Ronya, Land Council for the petitioner submits that he has an instruction not,
From the client, Your Lordship.
not to press. No, he has an instruction to withdraw this writ petition. Mr. MS, you are?
I'm for the private respondent. I don't have any objection.
Mr. Mr.
M. Kambo,
M. Kambo, Land Council for.
private
You are
respondent.
also here. Mr. B. Picha, Land Standing Council RD and Mr. M. Kambo, Land Council for the respondent number 4 are present. Accordingly, the petition stands closed on withdrawal.
Your Lordship, if I may be allowed to withdraw with liberty, Your Lordship.
Liberty.
Yes, because so there's both the petitions.
With the liberty to
Yes.
Huh?
Oblige, Your Lordship.
separate, same but separate order.
The same section is disposed.
Yes.
Item number 1.
What is the order?
My lord,
To have been violated?
page number 40, my lord.
40.
Yes.
40.
40, my lord.
Ah.
The Honorable High Court was pleased to direct Chief Secretary, Government of Arunachal Pradesh, to dispose of the representation dated 17/6/2022 within period of 2 months.
Hmm.
That has been just keep lingering under there. When we approach, they just says it is under consideration and they have not disposed of. At least they could have disposed in either means.
16/8/2024.
Yes,
Then
16/8, my lord.
16/8 order.
16/8 order.
How many years now?
It has been 14 months now.
Then what is the limitation?
My lord,
Section
actually,
20
limit,
of the Court Act.
my lord, limitation is 1 year. It is exceeded 2 months now.
Then
My lord,
you file a fresh petition, no contempt.
my lord, just with any orders to file the press petition with the liberty.
We'll not say, we'll close it, being barred by section 20, with a liberty to
File a press petition.
press representation.
Press representation. My lord, press representation has given this.
We cannot, we may not again entertain your writ petition also. Because once order is passed, same direction will be issued at best.
Yes, my lord. Yes, my lord.
So how do we pass again and again, same order, over and above?
My lord, on this basis of this,
Not limitation, contempt of the Court Act, 1971.
my lord, on this basis, on 16 January, a representation, a reminder letter was also submitted. But
Have you checked it?
a reminder letter.
No. Provision of the law.
Yes, my lord. That is there.
You have missed the
But,
bus, that's all.
The 1 year that is there. My lord.
This direction was within two months.
Direction was, my lord, it is your lordship has passed the order for disposal of the representation dated. That is in page 40. 41, 40.
Sorry.
8. Relevant portion is at paragraph 8.
Yes. How to overcome this section 20?
Yes, my lord, that is the 2 month, honestly, that 2 month has been, but in the meantime, I have had a reminder letter that also has been just being considering, and is from the scenes of the filing of the forwarding of the Honorable High Court order, they are being considering, but they are not disposing the representation because the basic direction was for the disposal of the representation dated 17/6/2022. That has been not done, and just they keep saying, and my petitioner being the level class category, and they don't dare to interrupt the directions of the authority, government authority. That is because this matter is connected to the bonded labor.
Heard Mr. M. Nebo, learned counsel for the petitioner. The order dated so and so, alleged to have been violated. No. The order of this court alleged to have been have not been complied with willfully, having been passed on 16/08/2024 is hit by the section 20 of the Contempt of Courts Act 1971 as the same as the present contempt petition has been passed. Filed after the lapse of after the expiry of a period of 1 year, this court is of the considered view that present petition is not would be cannot be entertained accordingly. Contempt petition is closed. On withdrawal,
My lord, so this would be coming for second round of litigation.
apply your mind. Have the best of your wisdom. What can you do? Because of section 20, I'm dismissing, closing it.
Yes, that is.
Cannot be entertained.
Yes, that is.
Thank you.
Item number 23.
Obliged.
Yes.
My pleasure, Lordship. Item number 2 and 3 is in fact a connected matter, Lordship. This item number 2, during the pendency of item number 3, CRP, the dispute in regards to the lane, that very order, Kawang order, was put to challenge before this court in the form of CRP. Now, during the pendency of this item number 3, the impugn that has been put to challenge in item number 2 was passed. That is the whole crux of why these two matters are connected, Lord. During the pendency of item number 3, the impugn order that has been put to challenge in item number 2 was passed. Lordship, the order, Lordship, will find in item number 2, page 25, annexer 5.
Page 35.
25, Lordship, 25.
My lord, may I please, I may be allowed to withdraw the on the petition. That will be better.
Then
because-
you just lost, having realized, second last, huh? Second last, having realized that the petition cannot be entertained. Mr. M. Nebo, learned counsel for the petitioner fairly submits that he may allow to withdraw the contempt petition. Prayers allowed accordingly. So it's
Obliged.
yes. You are challenging this.
Lordship, in the writ petition, Lordship, page 25, annexure 5, Lordship.
What
Now
does,
this is shown to be a cover decision, but this is not a cover decision. Rather, it is a arbitration board decision, Lordship. In the previous order, Lordship will find that commonly 21 page 20.
this is a Kabang decision.
But then, Lordship, this is not a Kabang decision, Lord. Rather, it's a arbitration board decision, Lordship.
Ah,
They have wrongly said it to be a Kabang decision, but it was not a Kabang, Lordship.
so what does it say?
Lordship, the ex parte order was passed. Here, Lordship, we were not present on a day, but ex parte order was passed in favor of the private respondent, Lordship. Pupor clan. I'm Puchung clan, they are Pupor clan, Lordship. I'm challenging this very order, Lordship, on two grounds.
Submitted by Pupor clan and also carefully study the case recording in hands where of the concerned with that were not in the position interpret the decision passed by additional deputy commissioner. And a natural justice given to both parties on this case is already decided case. And the accusation of the stressful circumstances have been declared as the clear line. What is the order here, CRP?
Lordship, that order I have annexed that page.
That has
Page-
been upheld.
No, Lordship,
Like
that
this.
that is still pending, Lordship. In item number 3 is the CRP that is still pending, Lordship. That was still pending the dispute that was between the petitioners and the private respondent, Lordship, in my case. That particular area, Tariq Lane, that was their Kabang decision was already there, Lordship. That was put to challenge in CRP, Lordship. That was state, Lordship. Now, during the pendency of this CRP, this impugn order has been passed, which I have shown it, Lordship.
So what is this? Yorni boundary to Sinkom, same land. It's a same land,
Lordship, same land, sir.
same land.
Same land.
How it is possible?
Lordship, so why, Lordship? In fact, Lordship, Lordship may kindly come to page 22, Lordship. Immediately after coming to know that the arbitration board has been constituted, Lordship, we have, in fact, after coming to know, we have submitted this representation also. We have apprised the authorities regarding the pendency of the CRP before this honorable court, Lordship.
So that decision of the Keba has been decided again here.
No, this is separate decision. This is arbitration board decision. Kabang decision is another decision that is put to challenge in CRP, Lordship.
No. Here, my lord, in CRP, my lord, initially there is a Keva decision, my lord, chicken liver test, my lord. Against that, my lord, they have preferred an appeal before the additional deputy commissioner. Additional deputy commissioner upheld the, my lord, Keva decision, my lord. Therefore, again, they have preferred an appeal before the deputy commissioner, Allah, my lord. The Allah deputy commissioner has remanded back the matter to deputy commissioner, and deputy commissioner again, my lord, after upholding by himself, my lord, has constituted a board, my lord, for re-decision, my lord. That was challenged. Constitution of the board was challenged in the CRP, my lord. And by now, and that was stated by this honorable court, my lord. However, my lord, by a different board, my lord, which was challenged in this writ petition, the decision has been taken, my lord.
Same land.
Same land.
My land is,
In respect of same land.
but
Same land.
no, I cannot say that, my lord. In my case, my lord, it is Tali Arik, my lord, land. My lord.
It says here, who has filed the writ petition?
Lordship, I have filed.
Lordship, may kindly There was the page 9 of my affidavit, Lordship.
Affidavit,
Which has been written Kebang decision, but is arbitration board members. Has been.
where in your,
Lordship, second para.
which CRP?
No, Lordship.
In
It's
CRP,
130, WPC 130,
page, running page?
page 9.
Okay, affidavit, yes.
Lordship. This is the decision. In the second para, Lordship, you can see that the respondent party, Sri Thamel Kupor, Lordship, is,
Affidavit by,
no, not affidavit, Lordship. This is the
no,
an order.
affidavit in opposition filed by respondent number 2.
Yes, Lordship.
Okay, page 9.
Page 9, Lordship.
Yes, judgment and order.
Yes, Lordship, it says here that the respondent party, Sri Thamel Kupor and his party were present, but the complainant party named is Sri Pagden Puchung, the petitioner here, Lordship. Sri Taku Puchung remains absent here. Absent. Sri Mire Puchung was present, but he withdrew himself from this case, citing that his land is not included in the dispute portion. They remained absent and they said this, Lordship. And then, Lordship, this arbitration board members are different from the CRP, Lordship.
So tell us whether it is the same land or not.
Same land only, Lordship. Same land only.
Same land.
Same land, sir.
My fact of the case is that the respondent here, 1, 2, and 3, they are the actual and real owner of the land. And they are the complainant in the beginning.
Who is the, who are they? Who are they?
That is,
In writ petition?
Lordship, yes, writ petition 1 to 3.
Chen Puchung, Aku Puchung,
Ame
and Bojung Puchung. So, my lord, there are several orders passed by the additional deputy commissioner, Michuka. And they went up to the deputy commissioner also by appeal. So, appeal is still pending before the deputy commissioner. So, my humble submission before you, lordship, that let the matter be remanded back to the additional deputy commissioner, who is the original jurisdiction of that area. And this become a matter of disputed.
No, by this Kebang decision, page 25, that has been decided now.
But by river test, my lord. We can river test.
No.
Permitted to have this kind of decision. And this matter is being lingering since 2017, man. So it will be better if lordship direct the additional deputy commissioner.
Where is this 13-12 decision? 13-12-2017 decision?
In my matter, page 36, my lord. In my civil revision petition, my lord. Before that, my lord, Keba decision is at my lord, page 31, my lord, page 32, my lord.
CRP.
CRP, my lord.
This is
the Keba decision, my lord.
Page 31.
32, my lord.
32.
Yes, ma'am. Is the Keba decision, my lord. And against that, my lord, they file a appeal, my lord. My lord, before the additional deputy commissioner, my lord will find at page 34. And the additional deputy commissioner has upheld the Keba decision, my lord. Lord, she will find at page 36, my lord. That is 13-12-2017. May I read, my lord?
Yes.
Whereas this office has approved to settle the dispute case between Puchung versus Pupar in arbitration under the Assam Frontier Such Act 1945. Whereas this office has served an order to both the parties for submission of list of arbitrators on or before 17/11/2017 by order such and such. But instead of submitting the list of arbitrators, both the parties has gone for local kava, which finally was decided through a chicken liver test. The decision was taken through the chicken liver test, has also submitted to undersign on 29/11/2017. Hence, you have lost the opportunity to be heard at arbitration board level, thereby left no no any scope for undersigned to get the case be tried, but only option remain is to uphold the decision taken through the chicken liver test, my lord. Well, against that, my lord, they have again filed an appeal before the Deputy Commissioner, my lord. Lordship will find the appeal at page 37, my lord. This was
How
this.
this appeal will lie?
Well, that's why this is the my case, my lord. There cannot be two appeal, my lord. Additional Deputy Commissioner and the Deputy Commissioner are, my lord, having the same power, my lord, authority, my lord. And additional.
Then thereafter, what?
Thereafter, my lord, Deputy Commissioner has remanded back the matter to the, my lord, the additional Deputy Commissioner, my lord. Lordship will find at page 46, my lord.
Then
My lord, the additional Deputy Commissioner, my lord, by the impugn order, my lord, constituted a committee, my lord. Lordship will find which is impugned, my lord, at page 53, my lord. 4/4/2018, my lord. At page 54, my lord. These are the committee members, my lord. Hence, the board is hereby directed to conduct the inquiry and amicably settle the instant case. After settlement, submit the case decision to the undersigned within 10 days from the date of issue of this order, my lord. This order has been challenged before this in the, my lord, CRP, my lord. On the ground that, my lord, once, my lord, in an appeal, the additional Deputy Commissioner has upheld the decision of the, my lord, Blaze Authority, my lord, there cannot be another appeal before the Deputy Commissioner, my lord, having same appellate jurisdiction, my lord. And pursuant to the remand by the Deputy Commissioner, the additional Deputy Commissioner has passed this order, my lord, which is not permissible in law, my lord. This was my case in CRP, my lord, and so this was stayed by this honorable court, my lord.
Then during the pendency, another decision,
Another decision, my lord,
which is in your favor.
in my favor, my lord.
So you are respondent there.
Yes, my lord. But, my lord, my learned friend appears there, my lord.
Huh?
For the respondent, my learned friend appears, my lord. Yeah.
So it's become infructuous.
Infructuous. For me, my lord, it's infructuous, my lord.
Your CRP.
Yes, my lord.
Because subsequent decision has been arrived with, of course, upholding the earlier Kaba decision.
Yes, yes, my lord.
1312, right?
Yes, ma'am.
13/12/2017.
Yes, my lord.
So we'll close this CRP.
Lordship,
You are
one
for whom?
Lordship, I'm for the respondent in the CRPC, Lordship. In the writ petition, I'm the petitioner, Lordship.
So this become infructuous.
Lordship, that is one of the ground, Lordship. During the pendency of this matter, this arbitration, again, another arbitration board was constituted, Lordship.
That is, you have
Page-
to challenge.
Lordship, yes, page 21.
Today it's become infructuous.
Today,
Isn't it?
yes.
We'll close this in that case.
Yes, sir.
Heard Mr. Arsake, learned counsel for the petitioner,
Petitioner, my lord.
and Mr.
I'm in the writ petition, not in the CRP, Lordship. If your Lordship is closing the,
You are respondent.
he is the respondent.
And CRP state is there, no?
No, no, my lord.
And Mr. Fisher, learned counsel for the respondents.
1, 2, 3.
1, 2, 3. All the respondent. Now, how many respondents are there?
Yes, all the respondent, my lord.
challenge in this revision petition is to the order dated
And the 4/4/2018, Lords will find at page 53, my lord.
2018 passed by the Additional Deputy Commissioner West Siang District. Additional Deputy Commissioner Mechuka, whereby the Additional Deputy Commissioner Mechuka had constituted a board consisting of 6 members to settle the land, for settlement of the land. What
Tali
land?
Arik, my lord.
Where do you get it?
My lord, in my synopsis also, my lord.
Tali Arik.
Tali Arik,
Tali Arik.
located at Rapum village, my lord.
Located at Rakum.
Rapum village, my lord.
Rapum.
Yes, my lord.
R-A-P-U-M.
Yes, my lord.
Rapun village. Mechuka.
Mechuka, my lord.
Mr. During the pendency of the revision petition by an order dated where it is in that subsequent decision
Subsequent decision, page 25, Lordship.
by Kebang decision dated 22/09/2020. It has been decided that there is no ground to interfere with the decision passed by Additional Deputy Commissioner Mechuka dated 13/12/2017, which is put to challenge in WPC 13 of 2021. 2021. Having considered that subsequently by an order dated 2020, that same order matter has been decided by the Additional Deputy Commissioner. They decided by Kebang decision that it 22/09/2020. But the present revision petition has become infructuous. Accordingly, the CRP strength goes up as infructuous. Now, WPC. So you are here.
Lordship, yes, I'm here.
You are no longer here.
No, no, no.
Okay.
Mr. Son.
You same, some respondent. Yes, what can we do? What is to be done now?
Lordship,
See,
my
they
prayer is
failed the Kebang decision. All right,
correct, Lordship.
13/12/2017.
Yes.
So what's wrong?
Lordship, this is actually a arbitration board decision, Lordship. Now, arbitration board decision at that point of time, Lordship, it has to go as per regulation 38 of AFR, Lordship. Now, all those conditions was violated during the whole process while coming to this judgment and order, Lordship. That is one of my ground, Lordship. Another ground is, Lordship, during the pendency of the CRP, they have come up with this order, Lordship, which is in fact contemptuous
No,
against.
there's a stay of the earlier decision.
Of course, there is a state, Lordship. We have informed
There's
the
no bar to have a fresh look at this decision by the authority.
Lordship. At least the matter was sub judice before this honorable court, Lordship. That matter was repeated representations, Lordship. Through representations, we have apprised the authorities. Lordship, may kindly come to page 23, Lordship. In our representation, Lordship, we have clearly apprised regarding the pendency of this CRP before this honorable court to the authority concerned, Lordship. Now the authority concerned, Lordship, in the down below, Lordship, will see in written there, Lordship, by the circle officer. It's clearly written to the chairman who was appointed as the chairman at that point of time, not to go ahead. He was clearly directed not to go ahead.
Where it is?
Lordship, down below, Lordship, page 23 of my petition, Lordship. In my representation itself, the CEO has marked to the chairman RALLDC, Lordship, down below, Lordship. It's a handwritten, Lordship. Lordship will sign the signature and the seal of the circle officer, CEO Mid District Machuca, Lordship. Now here, Lordship, the circle officer has clearly directed the chairman not to go ahead with the case, Lordship. In spite of that, they have
You are directed to, what is this?
stop this case from your trial hearing.
Stop.
Since, yes, Lordship, since this case is in High Court, Lordship.
Then,
Lordship, in spite of this clear direction, Lordship, this page 24, Lordship, annexure 4, Lordship. Now here the chairman who was appointed as the chairman, committee chairman, Lordship. Now he is the one who is constituting this board, Lordship. Page 24, Lordship. Now this is clear violation of article regulation 38 of AFR, Lordship.
24.
24, page 24, Lordship. Annexure 4. The chairman, Lordship. Normally, under regulation 38, Lordship is aware, Lordship, that the arbitration board is generally constituted by the ADC or the DC. Upon consultation with both the parties, Lordship, they submit their members and then it is constituted, Lordship. Rather here, Lordship, the chairman, he is acting as the ADC, Lordship. He is exceeding beyond his
Why
jurisdiction.
this additional deputy commissioner has put his signature? Additional deputy commissioner CEO Mid District. Huh?
Page 24, Lordship.
No, 25. Who has decided this?
This is the certified copy, Lordship, given by the ADC. He is the
Who has decided this?
So Lordship will see at page 27, Lordship. Arbitration board member, Lordship. Singlok Koje, umpire, member, Lordship. Generally, regulation 38, the decision is generally passed by the DC or the ADC. Both the parties will, after the decision, both the parties will go.
What happened? Now what will happen? Arbitration is no longer there.
It's no longer there, Lordship.
Then
Now this impugn order was passed before coming of AP Civil Court, Lordship.
it doesn't indicate the arbitration proceedings. Chairman of the arbitration board constituted by the administration for the land ownership dispute.
Lordship, may kindly come to page 21, Lordship.
Stretching from Gapo village to Namro Sokang. This is something different.
Lordship, page 24.
Description of the name of the land. is
Page
different.
24, page 24, Lordship, annexure 4, Lordship. I, Sri Songlang Koje, the chairman of the arbitration
There's a
board.
proposed highway right of way stretching from Gapo village to Namro Sokong. Huh?
Now that the disputed lane, since it is falling under the Trans Highway Road, Lordship, so why this board was constituted, Lordship? The committee, page 21, Lordship, was constituted, Lordship.
Sinyi Sotong. Page 25, you come. Please come. The land is between Sri Pugjan so and so has been taken up for hearing on so and so at Kemangar Machuca regarding area of land located near Sinyi Sotong. Is it the same land?
Yes, Lordship, area, but the name of the lane is Tari Tali Lane, Lordship.
Then it doesn't indicate here
Tali Arik Lane dispute, Lordship.
where it is.
Of course, in the Kaba decision, it's not mentioned, Lordship, but it's the same lane, Lordship. That is not disputed, Lordship.
So what can be done?
Only my query is that the land is not the same area, man. My land is Kirik village, HIRR, Kirik,
Hmm.
Kirik village.
Hmm.
That's got the petitioners. This is totally different. Man.
Yes. Record also indicated. You may say that it's Arik Lane. He said Sotong something. And the location is also different.
Name of the lane is Tali Arik Lane, Lordship.
Hmm?
Name of the lane is Tali Arik Lane.
In the impugn order.
No, in impugn order, Lordship, it's not mentioned, Lordship.
Something different. How do you know?
Lordship, one of my ground is this only, sir. Lordship, since the lane that is put to challenge dispute in the CRP is the same lane, so why it is writ petition, Lordship. One of my main ground is that only, Lordship.
What?
One of my main ground is that only, Lordship.
What is your main ground? What is your main ground?
One of my main ground is, as I stated, Lordship, it's the Tali Arik area, Lordship. It's the same lane, Lordship, which is put to,
But
which is disputed in the.
Different land. Hmm? Is it the same length, madam?
Only my
Affidavit is also something different. There's nothing.
Lordship, there is nothing in the affidavit, only saying that since the land has to be handed over to the executing agency, there was a need to negotiate with the people which land fall within the right of way. That's why this mediation was done.
It's a common for common the dispute.
Yes, Lordship. If you
Where one of the order is also this page 9. That is what you are saying.
Lordship, if Lordship see my annexure 7, the ADC got the letter from the LRSO, Lordship, asking them to mediate with the people as early as possible so that the land in question can be handed over to the executing agency.
It's not clear which land is. What is to be done?
It case where the lordship please to remand it back to the ADC.
Who will? ADC?
ADC.
ADC will not have any power now.
Lordship, may kindly make the observation that parties may approach the appropriate forum accordingly, Lordship.
We may say so.
Lordship.
Yes, Lordship.
We'll just provide you the liberty,
Yes, sir.
eh? Without interfering with this.
No, Lordship, this has to go, Lordship.
You may have to file an appeal against this.
Lordship, that is one of my ground again, Lordship. This is not a Kaba decision. This is rather a,
You have, they said it's Keba decision,
in fact,
Kebang decision, judgment and order.
Lordship, the way the board was constituted, Lordship, as I have shown, Lordship, page 24, Lordship. It clearly talks about arbitration board, Lordship. Now, arbitration board,
Yes.
it is constituted.
Mr. Jejini, then counsel for the petitioner. How many petitioners? One,
3, Lordship.
3 petitioners. And also MSG at the learned additional senior government advocate for respondent number 1 and 2, and Mr. as well as Mr. T. Sir, learned counsel for respondent number 3. By way of this application, the petitioner has put to challenge Kebang decision oblique judgment and order dated 22/09/2020 passed by the Board of Arbitrators, whereby the land dispute between the this is clan or what? Pupor clan and
Puchung clan.
Puchung clan. Is declined to be interfered with in view of the decision by the Additional Deputy Commissioner Mechuka dated 13/12/2017. As the dispute was already decided by the Additional Deputy Commissioner. Thereby holding the portion of land stretched from Yorni boundary to Singkom Singme is declared to be the land of Pupor clan, Pupor party, Pupor clan, represented by respondent number 3.
3.
You are Puchung.
I'm Puchung, the petitioner.
Briefly put, the case of the petitioner is that the petitioner's clan has been in possession of land called Tali Arik since time immemorial, without any disturbances from any corner. In the year 2017, a dispute has arisen between the petitioner clan and the respondent number 3 clan over the said land. Accordingly, several Kebangs were conducted. However, no decision was arrived at. The matter was referred to arbitration board for amicable settlement of the case. In the arbitration, the parties have agreed to go for chicken liver test, and on the basis of the undertaking, the chicken liver test was done. but claims that it was not in accordance with the and it was not done properly, as the same was not in accordance with the prevalent custom. Mr. The arbitration public Keba decision was against the petitioner. Against the petitioner, right?
Yes, Lordship.
What is that decision? First decision against the petitioner.
CRP law. Yes.
Which were put to challenge. What is that? First decision, 13, 12, something. Thirteen, 12, 2017. Huh?
Page 34, Lordship.
Against which? 34.
Page 34, Annexer 6 series, 4 series.
In
CRP, Lordship. In CRP, Lordship.
you have not annex here.
Here I have not. I have only annexed
13,
the
12. 13, 12. Is 13, 12 or what?
13/12, 2017, page 36, Lordship. Yes,
13,
correct.
12, 2017. Against the petitioners. According to accordingly, a civil revision petition being CRP within bracket C number 12, 2018 was filed before this court challenging the orders of the additional deputy commissioner public Keba decision. During the pendency of the civil revision petition, the impugned order has been passed. The impugned Keba decision oblique judgment and order dated 22/09/2020 has been passed. Hence this petition. Next paragraph, Mr. J. Land Counsel for the petitioner submits to the order dated 22/09/2020, whereby purportedly board of arbitration was constituted in respect of this then dispute. In respect of dispute, in respect of land dispute of Tali Arik was not in account is not in accordance with the provisions of the then Assam Frontier Regulation, Administration of Justice Regulation. Huh?
Yes.
Assam Frontier within Administration of Justice within bracket was 45. As the additional deputy commissioner or deputy commissioner has not referred the matter to arbitration in terms of regulation 38 of AFR 1945. Then The arbitration, Board of Arbitrators was nominated, constituted by the chairman of arbitration, without any jurisdiction, as it is only the deputy commissioner or assistant commissioner who are mandated under the law to constitute a board and refer the matter to for arbitration. Mr. Gini learned counsel for the submits that the impure among decision of judgment and order has been passed expert that too, when the similar issue was in session of the Honorable Court in Honorable High Court in CRP C number 12 of 2006. Therefore, he submits that the impugn order that is 22, what is that?
09.
09/2020 may be set in cost. Next paragraph. MSG of the Learned Council, while referring to the affidavit of opposition filed on behalf of respondent number 2, submits that in view of the complaints and counter complaints from various quarters during the survey carried out by Land Management Department for construction of road from Tato to Mechuka, the additional deputy commissioner has constituted a board of arbitrators, whereby one Singlong Koje, whereby Sri Singlong Koje, ex-ASM as the chairman, Tani Komi, ex-ASM as member, Rabden Koje as member, page 8 of the affidavit, including the concerned head GBs / GBs of the respective village as members. Pursuant to the order dated 22/09/2020 was passed by the Board of Arbitrators, whereby it was found that the land dispute in question was already settled by the by a decision of the additional deputy commissioner Menchuka by the orders dated 13/12/2017. And accordingly, it has been held that a portion of land distressed from Yorni boundary to Singkom Singme has been declared as the land of Pupur Party, Pupur clan, Mr. Duhar clan, as decided earlier. Next paragraph. Therefore, there is no illegality in deciding the matter. That too, when the matter was already settled by earlier Keba decision. Mr. petition learned counsel for the respond number 3 submits that the land in question is a dispute in question is related to a land, what is called Taliarik.
My is Miri area now.
Huh?
Miri is the name of the village actually. Miri village. It's the name of the village. It's not the area. It's not the area. It's a village name. Now that Tariarik lane is coming under Miri village.
That is his submission. He submits that land in question. No, the decision in respect of the land, this disputed land was already settled by an order that by a decision dated 13/12/2017, and the Board of Arbitrators merely after consideration of the evidences and the records, has decided that there is no reason to interfere with the decision already passed by the Additional Deputy Commissioner. And accordingly, the land stretched from Yorni boundary to Singkam Singme has been declared in favor of the respondent number 3. In favor of the Pupur clan represented by respondent number 3. He submits that the land claimed by the petitioner and the respondent number 3 are two different and distinct land, as the impugn order does not disclose the land disputes to be a Arik land.
Taliarik.
Aliarik. Tali.
T-A-L-I.
Rather, it is shown to be a stretch from Yorni boundary to Singkom Singme.
That is the Chinese area, Chinese. In the Chinese, this Taliarik area is.
Joining the submissions, his submission, Mr. T. Land Council for the petitioner. J. sorry. Land Council for the petitioner submits that there is no dispute as regard the land dispute of Taliarik. The straits mentioned in the impugn order so and so, dated 22/9/2020 is only the straits of the land without mentioning the exact name of the land dispute. Stuff. I have considered the submissions of Land Council for the parties. And also, there is the materials on the court. The land dispute in respect of Taliarik appears to have been decided way back in 13/12/2017, which was put to challenge in CRP number 12 of 2018.
Madam, I make clear one thing, madam. 13 was not put to challenge in the CRP matter. In fact, madam, we are seeking uphold of the 13/11/2017 matter. Madam, because my lord, against the Keba decision, my lord, they preferred an appeal before the my lord.
Same authority. Challenge was not 13.
No, my lord, it was upheld. Upholding the Keba decision, my lord.
Which is in your favor.
Yes, my lord.
Ah.
In my favor in the civil revision petition. Against that, my lord, they have preferred an again appeal before the deputy commissioner, my lord.
13 is in your favor.
In my favor, my lord.
Okay.
It was upheld by the additional deputy commissioner
Ah.
in a CABA decision, my lord.
Okay.
After the interference by the my lord, deputy commissioner, my lord, remanding back the matter again, the additional deputy commissioner again, my lord, constituted a committee to rehear
That was
the.
put to challenge
That was put to challenge, my
in
lord.
CRP.
Yes, my lord.
Okay. Decided on 13, 12,
13/2/2018, my lord.
not 12.
No, my lord.
It mentioned 13, 12.
Yes. My lord, CABA decision is, my lord, 26/11/2017, my lord. In my favor, my lord. It was, my lord, put to an appeal, my lord, by the writ petitioners, my lord, and respondent in the civil revision petition, and upheld by, my lord, 13/12/2000. Yes, my
And
lord.
in case this CABA decision earlier, 26/11/2027, 17, which was appealed by the against which appeal was prepared, and same was appealed by the additional deputy commissioner Mechuga
My lord.
by order dated 13/12/2017.
My lord.
Thereafter,
Thereafter, my lord, they again filed an, my lord, appeal before the DC, my lord, having concurrent appellate jurisdiction, my lord. And the deputy commissioner by order dated 31/2018 has remanded back the matter to the additional deputy commissioner, my lord.
thereafter again an appeal was filed before the deputy commissioner
My lord.
Alo
Alo, my lord. And deputy commissioner Alo
by an
by an order dated 31/2018,
deputy commissioner Alo by an order dated 31
1
1 2018
18 remanded back
again
the matter
remanded back the matter to additional deputy commissioner,
Mechuka, my lord.
which was put to challenge in CR.
No, it was also not put to yes, my lord. It was also put to challenge along with the, my lord, another impugn order dated 4/4/2018, whereby the additional deputy commissioner has constituted certain board members to resolve the issue, my lord. That was put to challenge, my lord.
Put to challenge, and another order constituting arbitration board of arbitrators
My lord.
was put to challenge in CRP 12 of 2018. During the pendency of CRP 12 2018, the impugn order has been passed, whereby the order dated 26/11/2017 passed by the CABA decision dated 26/11/2017 passed by the and upheld by the additional deputy commissioner by that order dated 13/12/2007 is declined to be interpreted with as the and accordingly the portion of land stretched from Yornyi boundary to Singkom Singme has been decided in favor of in favor of the Pupor party, represented by the respondent number 3. The next para. Upon consideration of the provisions of law with regard to reference and constitution and reference of board of arbitrators as then begged, as then invoked under Assam under section 38 of Assam Frontier so and so 1945. It appears that the constitution, it just appears to have not been done in accordance with the mandate of the law. Stuff. However, by lapse of time and on repeal of the provision, arbitration provision is prescribed, then under AFR 1945, the dispute now is to be resolved either by an appeal or by a suit, fresh suit. Stuff. Next paragraph. The record further record reveals that the chairman was appointed by the additional deputy commissioner. However, other members of the board, arbitration board, and the board of arbitrators were appointed by the chairman. Of one Ramo area land dispute case, which is not in accordance with the mandate of the law. The initial Keba decision dated 26/11/2017, having been put to challenge by way of appeal before the additional deputy commissioner, and the additional deputy commissioner having been decided, issued by an order dated 13/12/2017. There could not have been any further appeal by the parties before the deputy commissioner. Since no further appeal could have been maintained before the deputy commissioner, the consequential order of referring to the matter back to the additional deputy commissioner, who has already decided the appeal against the Keba decision dated 26/11/2017. The is also in not accordance with the provisions mandated under the law. The present impugned order appears to have been passed consequent to the further appeal, even after the decision by the additional deputy commissioner dated 13/12/2017. Thus, I'm of the considered view that the Kebang decision of the judgment and order, although upheld the decision, upheld the Kebang decision dated 26/11/2017, and the order dated 13/12/2017 passed by the additional deputy commissioner Mechuka, it cannot be sustained. Mr. In view of the above, I deem it appropriate to dispose of this present writ petition. No, in view of the above, the order dated the Kebang decision of the judgment and order dated 22/09/2020 is not sustainable, as the same has not been passed by following the due process of law, particularly Section 38 of AFR 1945 in referring and in referring and again constituting and referring the board of arbitrators. Mr. According the same is set aside in cost. However, it is provided that the parties may approach the appropriate forum as may be permissible under law, as may be permissible under the law. Ultimately, the Keba decision remains.
Yes.
13-2.
Yes. Legally
And then
speaking, my lord,
26-11.
they have to file
26-11 and this thing
12.
12 because they have just simply upheld their.
So
See what you
legally,
can-
they have to file a second appeal, my lord.
Huh?
Second appeal before this honorable court.
Lordship, that will. Obliged.
Dispose of. Huh?
Item number 5.
Yes.
May please, Your Lordship.
Yes.
My lord, here in this writ petition, my lord, we have challenged an inaction on the part of the authorities in not registering an FIR which clearly discloses a cognizable offence, my lord. Now, my lord, this, if your lordship will find, my lord, the crux of the matter is like this. My lord, there is a huge money sanctioned by the government of Arunachal Pradesh for the welfare of the building and construction workers, my lord. And every year that money is to be utilized for the purpose of the welfare of the poor construction workers. Now, my lord, that money has been, that those monies were siphoned by the ex former chairman and the secretary, my lord, and they, to that effect, my lord, the FIR was lost by the petitioners, my lord. The lordship will find the FIR at page 42. May I just read it, my lord? It's a long FIR. Upon receiving a numerous complaints and substantial evidence, would like to inform you about the illegitimate and fraudulent practices of the Arunachal Pradesh State Building and Other Construction Workers Welfare Board under the leadership of so-and-so, the former MLA, former chairman, during the tenure of so-and-so, former secretary of the board, so-and-so OSD to the board chairman, so-and-so present finance and accounts officer of the board, so-and-so present accountant of the board, so-and-so and so-and-so member secretaries of the board, and so-and-so RO come former OSD to the previous chairman, aided in fraudulent utilization of the cess money meant for implementing welfare schemes for the benefit of poor construction workers in the Arunachal Pradesh. As a result of their action, these workers were unjustly deprived of their rightful benefit. Here are some specific instances. That's how it is to inform and intimate your esteemed office that every year since the establishment of the Arunachal Pradesh Building and Construction Workers Welfare Board, the government of Arunachal Pradesh has collected crores of rupees from the labor cess and other applicable taxes for those sole purpose of the welfare of the laborers of the state as a whole. However, the same has been illegally engulfed and siphoned up by the aforementioned officials who have abused their official power and position. We have been conducting research on so-and-so for the past 6 months in response to numerous complaints and representations from the improvised workers across the state, especially the board laborers. The investigation and my research work has uncovered that every fiscal years, crores of rupees are being received or collected through labor cess for the welfare of the laborers workers of the state. However, this amount is being misused under the disguise of supporting the welfare of the poor and innocent labor with no proper maintenance of accounting
Yes, what
books.
happened?
Now, after the FIR, though the FIR clearly disclose a cognizable offense under Indian Penal Code as well as the Prevention of Corruption Act, Now, the government in their affidavit has taken a stand, We approach this honorable court due to the inaction on the part of authorities for not registering the FIR, Now, the law is very clear on this point, Your Lordship knows. 5 judges bench of the Honorable Supreme Court in Lalita Kumari has said that once a cognizable offense is disclosed, the police has no power to say that will not register the FIR. Now, my lord, the government, the stand of the government that has been taken in the affidavit, if your lordship will find at page 58. Page 58, paragraph 4. Well, the government says that earlier there was a similar complaint by one person, and that person has withdrawn the complaint. So therefore, and the approval was not given in that complaint, therefore the approval is not given in this complaint as well. Paragraph 4, may I just read it, my lord? The issue raised in the writ petition is pertaining to the commission of offence of forgery and siphoning of government fund meant for Arunachal Pradesh Building and Other Construction Workers Welfare Board, Itanagar. The grievance of the petitioner is that though the complaint has been already lodged against some person in connection with embezzlement of fund of the board, but no case has been registered against the person. The matter was placed before the competent authority by the SIC for necessary approval as to register a regular case against the culprits. On perusal of the complaint, it is found that prior to the present complaint, another complaint was lodged by one Kurung Dule on so and so, which was placed before the competent authority for necessary approval. In that case, a report was sought from the concerned board. In the meantime, the complainant also filed an application seeking withdrawal of his complaint. Accordingly, considering the report submitted by the concerned board, the competent authority closed the proceeding. In view of the above, since the allegation is same and the same subject matter, which has already been examined and considered, a decision has been taken to close the present complaint lodged by the writ petitioner by the order dated 22/01/2025. The order, my lord, will find at page 62. The second paragraph, my lord, will kindly refer, where prior to this, a similar complaint from so-and-so was also received by the department on the same issue, and on its received comment report from the Secretary, Labor and Employment, Government of Arunachal Pradesh was obtained. Whereas after perusal of the comment report of the Secretary so-and-so, nothing adverse was apparent, and accordingly the matter was disposed with the acceptance of the report with due approval of the competent authority. Therefore, the instant complaint is submitted by so-and-so on the same aforesaid issue is hereby disposed after perusal of the comments of the so-and-so, as it warrants no further action. So my lord, the basic contention of the government is that earlier there was a similar complaint by somebody. That person has withdrawn it, and in that complaint, some reports were called from the Secretary of the Labor and Employment Department, and based on that report, as earlier complaint was disposed, therefore no approval has been given. My lord, in my respectful submission, my lord, this is absolutely violation of the law that is laid down by the Honorable Supreme Court in Lalita Kumari, my lord. May I just refer to the judgment of the Lalita Kumari, my lord? Well, I've given a copy the judgment which I'm relying on. My lord, I'm referring to a judgment of the Honorable Apex Court in Lalita Kumari. My lord will kindly first allow me to take your lordship to page 14, my lord, the running page 14, paragraph 39.
Page
Page 14, my lord.
14.
Para 39. Yes, my lord.
Yes.
My lord. Consequently, the condition that is sine qua non for recording of an FIR under section 154 is that there must be an information, and information must disclose a cognizable offense. It is if any information disclosing a cognizable offense is laid before an officer of the police station satisfying the requirement of section 154(1), the said police officer has no other option except to enter the substance thereof in the prescribed form, that is to say, register case on the basis of such information. The provision of 154 is mandatory, and the concerned officer is duty bound to register a case on the basis of the information
Okay,
disclosing
there's
a
no
cognizable
dispute.
offense. There's no
No, it's
dispute.
a
In
settled-
fact, my lord, yes,
settled
if your
position.
lordship will kindly see the ratio, my lord.
But here,
Yes. My lord, the plea what has been taken by the government, my lord, in the ratio of this judgment at paragraph 111, my lord. My lord, there are the honorable court has, apex court has said, even in cases of certain offences, one can go for a preliminary inquiry, my lord. But the limit of the preliminary inquiry is only to see whether the offence discloses a cognizable offence or not the veracity of the allegation. If my lord will kindly be pleased to see paragraph 111 for a moment, my lord.
yes, I've seen it. Yes.
Oh, my lord. My lord, here I'm appearing for 3 and 4, my lord. My lord is well aware of the provisions under section 17A of the PC Act, my lord. Now, my lord, PC Act says, my lord, may I read it, my lord?
Who has filed the affidavit?
Affidavit has been filed by the government. my lord. There is an embargo on the
You file a detailed affidavit, bring on how it was considered, how it was rejected. Just because a similar matter was withdrawn, you just can say that similar matter, somebody has filed another matter. But withdrawn, one could understand if it is disposed of after a preliminary inquiry or whatever you take a decision. Your reason appears to be that somebody on the same allegation, there was a complaint that has been withdrawn by that complainant. Now you don't, this is the same issue. That cannot be.
Lordship, just kindly come to page 62 of my affidavit. Lordship. Kindly see the one. There's the two part, Lordship. The one is the withdrawn, Lordship. And when Lordship, any Lordship,
60?
Page 62, Lordship, and one of my affidavit, Lordship. Just allow to read the second paragraph, Lordship. Whereas prior to this, a similar complaint from one ship so and so was also received by this department on the same issue, and on its received, comments oblique report from Secretary Labor and Employment Government so and so was obtained. This is a concerned board lawsuit where embezzlement is said to have been committed. Whereas after perusal of the comment oblique report from the Secretary so and so, nothing adverse was apparent. And accordingly, the matter was disposed of with acceptance of report with due approval from the competent authority. Here, Lordship, two parts, Lordship. One is the complaint was withdrawn. That's one part, Lordship. A second part is that, Lordship. In response to that report, Lordship, that complaint, Lordship, we sought report from the concerned board, Lordship, where the embezzlement is said to have been committed, Lordship.
That was the FIR is against the secretary also. You have heard from that.
That is the Lordship. But what now, Lordship, keeping aside merit of the case, just I'd like to say, Lordship, one thing. This page 62, this order is the decisions of the government, which is not impugned in the present case. So my submission is the press course of action has arose by this very order, and the petitioner must challenge this very order.
When this, you have sought a report from or comments from Secretary Labor and Employment, whose ex-secretary is also an accused here in the FIR. How do you expect that?
This secretary himself, he was the same secretary or not?
No, otherwise also. Otherwise also.
Now, rightly or wrongly, Lordship, I have taken decision that Lordship that
Produce the record. You'll see how you have considered, what was the report of the secretary with detailed affidavit. And Mr. B. Kosik will consider further
Well,
on next day.
well.
Let them file a detailed affidavit along with the records.
Hello.
B. Kosik Land Counsel for the petitioner. Although the affidavit has been filed on behalf of the state. No, sir. Considering the allegations, considering the method, considering the nature of the issue involved in this petition, I deem it appropriate to allow further 2 weeks' time to file detailed affidavit by the state as well as the Say,
My lord, now
also
it-
filed.
now it is ACB, my lord.
Huh?
ACB.
SCB, huh?
But here, my lord, whether the ACB would require to file it or not, because it is an accepted.
Decision of the,
Yes, my lord.
and then state respondents and to produce the record. List after 3 weeks.
Grateful, Malad.
Item number 7.
Well, the Vigilance Department is refusing to give NOC so as to enable this petitioner who has superannuated from service on 31/5/2024. Well, he is a principal, my lord, and was arrested by the earlier SIC and now renamed as Anti-Corruption Bureau. And thereafter, the case was handed to the CBI, that famous paper leak scheme matter. So then subsequently, nothing had found against him. And in the supplementary charge sheet also, he has been dropped from the case. Now the department, now in this, my lord, will see in the affidavit in opposition, my lord, filed by the respondent number 2 in para 10. That will suffice the matter, whole matter.
Counter affidavit not yet filed by on behalf of respondent number 4. Who is respondent number 4?
Respondent number 4, my lord, CBI, my lord. Last occasion, my lord, we have received the parawise comment, but there are some mistakes in the, my lord, the procedure. So therefore, my lord, we prayed on the last occasion for filing affidavit, my lord. Today also, my lord, the same area, but some more time may be granted. In the meantime, we'll file affidavit, my lord.
Okay, last chance we will grant.
Only if my brother, if my learned brother DGSI can clarify whether he is his name has been dropped from the charge sheet or not in the trial case. That is,
Obviously, they will bring on record.
Yes, ma'am.
When you have
That is the required to be filed in the
you are
affidavit.
saying that you have pleaded there.
Yes,
Your name has been dropped.
dropped
Obviously,
in the
Well,
affidavit
Who has filed? The state has filed.
in the charge sheet.
No, affidavit.
The state has filed that there
Saying
is a-
what? What they are saying?
saying that there is a CBI case against him, and because of that we could not give. And I say that although CBI has registered the case, the wife has been charge sheeted along with the son, but I am not charge sheeted, and my name has been dropped from the charge sheet. So that is the sum and substance, my lord. The person is
in that case, affidavit of the CBI will be required.
CBI, my lord, I have given in my affidavit in reply, my lord.
Let them file.
I have brought on record the charge sheet, my lord. So my name is not there, my lord.
Let us see. Let them bring on record, black and white.
Please take short date, poor fellow is suffering.
Mr. T.T. Tara, Land Counsel for the petitioner.
Next, when? Give me, this is pension matter, don't take too much.
On the prayer of Mr. M. Kato, learned DOCI
So, okay, 16.
for respondent number 4.
My lord.
Further 2 weeks time is granted to file affidavit. it is taken not on record that the state has already filed the affidavit in opposition. You have also filed reply.
I have filed reply. I have brought on that CBI charge sheet where my name is
Now,
dropped.
when they say that there's a case against him pending before the CBI, whatever, criminal case, when they're saying that his name has been dropped and whatever, you bring up record?
Yes, madam. We'll bring on record, madam.
Yes, next.
27.
27 will be too early. 2 weeks, I said 2 weeks.
Well, can we have a fixed date?
2 weeks.
Somebody is suffering.
After 2 weeks.
3rd March.
3rd March, 2 weeks.
2 weeks.
Yes.
Great.
Next.
Item number 9.
Yes.
My lord, here I'm challenging the termination order, my lord. I was the petitioner and the 2 others.
Affidavit has been filed.
Yes, my lord.
Pleadings are complete.
Yes, yes.
What is the post?
Post is constable, my lord, civil.
After disciplinary proceeding?
No, my lord. No so-called notice was served and no inquiry was conducted. And but they terminated me from the force by saying that you have furnished wrong information, means conceal the fact, my lord.
Termination simpliciter.
No, my lord, it is during the filling up of the form, while applying that post, there is one question that whether you are convicted or not, whether any criminal case is pending before any court or
any
not.
judgment.
Yes, my lord. Yes, my lord. There, my lord, the question is so complicated that I could not properly understand the content of that question and fill up. No, my lord. It should have.
Although you were
yes, I
there
have
is a criminal case against.
Yes, my lord. That is
what
the
sort of what criminal case?
criminal case, my lord. 419 IPC. 419 IPC, my lord. That is the impersonation that I was acting as a member of APSU and collects 500 rupees from shopkeeper. That is the issue, my lord. And thereafter, case was registered. And that 500 was also recovered by the police. That is the issue, my lord. PT case, my lord.
Then recovered means you have been offense is proved.
No, my lord. In court, I was discharged.
Huh?
In the court,
Okay.
CGM court, I was discharged. Here, I have annex.
Okay.
Now, my lord, basically, I challenge that in 2 issues, my lord. No so-called notice was served before termination. That is a
How
clear
long you
violation.
have served?
No, my lord, so-called notice was not served.
No. How long you were in the service?
Service time, I am serving for this post 5 months, my lord.
5 months.
5 months, and completed the
You
training.
were under probation.
Yes, my lord.
Probation.
Probation, my lord.
And what is the law?
My lord, here the
Definition of the probation.
My lord, Sanjeev Kumar versus JP Pan Institute of Engineering. My lord, the relevant part is paragraph 18, my lord.
Yes.
My lord, on the perusals of the terminus order that may become framed that the decision to terminate the service appellant from the post of race are not preceded by opportunity to show cause any sort of disciplinary proceeding. My lord, this is also applicable. That is paragraph 18 and paragraph 19, my lord. In this background, we are from view that the termination of service appellant without holding disciplinary inquiry was totally unjustified and dehones the requirement of law. And my lord, there is also violations of Article 311 because no any inquiry was conducted, my lord. And my lord, against the termination order, file an appeal before the competent authority. Still, they have not heard the application, my lord.
Ingo. Yung dito. My lord, two other applicants have already approached this court and their petition was allowed. And the same, we are same base, my lord. 3 persons was terminated and 2 have already approached before this court and their case was considered by this honorable court, saying that, but their case is slight difference because they were declared as juvenile in conflict with law, my lord. But the nature of allegation is same, my lord, because we are the best in this cause, my lord. My lord, the relevant part of that judgment is page 18, my lord. May I read, my lord? Page 19, paragraph 18, my lord.
This also on the non-furnishing of the information.
Yes, my lord.
At a close level.
Yes, nature of allegation is really same.
He was he was not he was a prosecution witness. He was not an accused in this case.
Yes, my lord, but
Then,
but
therefore, when the question of he furnishing the information or disclose the information that whether he was arrested, prosecuted, kept under detention, or bound to be convicted by courts of law, he was not an accused.
but this court treated them as a witness, my lord. Even though my
He was
lord,
a prosecution witness.
yes, my lord.
Was not an accused. Completely. Yes, madam. Do you have this?
Lots of no.
Same order,
Yes, my lord.
same impugn order,
Yes, my lord.
but this is in respect of those 2 persons.
Yes, my lord.
One is first writ petition, one writ petitioner was not an accused, he was
Yes.
just a prosecution
Yes.
witness. Second one is he was a juvenile with conflict
Yes.
with law.
Yes, my lord.
Now, and there's a record, although fine one imposed
Yeah.
on his confession to the parents, and it's clearly provided, the magistrate has clearly said that it should not be future disqualification. Therefore, on their facts, their own facts only, it was interfered with. Termination was, the ground of termination was not correct.
Yes.
He was not bound to have that kind of thing.
My lord, my submission, my respectful submission is that, my lord, there is no inquiry was conducted. And no departmental proceeding and inquiry was conducted before termination, and no adequate opportunity was given. My lord, because there is a violation of Article 311, my lord.
Why? You are under probation. What is the law on the termination of probationer? Come with that. You share him also, the judgment? You share this copy?
Yes.
Will on some other day. Heard, Mr.
Titake, my lord.
Titake, Land Council for the petitioner. Considering submission to the effect that the coordinate bench of this court in WPC 25 AP 2025 and WPC 612 AP 2024 has interfered with the impugned order of termination. Similar, who is similarly situated with the petitioner here in comma. 2 weeks time is granted to learn State Council to go through this judgment.
I'm in one of the case already in this school. I attended in one of the, I'm one of the council there. So this is totally a different case. He cannot rely on.
You make a submission on that day.
Lots.
And also, the petitioner is also provided and is also granted some time to go through and to have a research on the law of termination of probationers.
Well,
I think you also find out when sitting at principal seat, I have also delivered on the same issue. Some judgment.
Yes, ma'am.
You may find out.
Item number 10.
Yes, sir.
My lord,
Today, we're little slow.
yes, my lord, I will consider the paucity of time. In fact, the clock is.
What is the matter here?
This is regarding, my lord, construction of CO office in my land, my lord, without acquisition.
Taxing?
Yes, my lord.
Back to pavilion?
Yes, my lord.
It has not been disposed of as yet.
No, my lord.
Why?
In fact, last week also, this matter came up, my lord, because of the paucity of time. It could not be taken up. Admittedly, my lord, the land is a private land of the petitioner.
Past. Any affidavit has been filed?
Yes, please, complete.
No, last occasion 22/9/20.
Yes, they have filed.
They filed.
Yes, my lord.
Saying what?
Saying that, my lord, the certificate, my lord, issued in favor of me by the GB, my lord. He has withdrawn that certificate.
Acha. That means?
But then,
that means?
Still, my lord, even,
that means?
The land, my lord, admittedly, the land is not acquired or donated by the public, my lord, the owner, the petitioner, my lord. And that fact, my lord, can be seen from the minute, my lord. Minute of 2 occasions, wherein the CEO
admit and list for hearing.
No, my lord. Then in that case, my lord, matter may be list for admission hearing again.
Today is not possible.
Then, my lord, let us have some other date.
After 10 days.
After 10 days, let it be on 5th, my lord. 5th March.
Straight for by land council for the petition minister. Dekamdu, Dekamdu. And as agreed to by Mr. Estafin, senior government advocate. Let this matter be listed on 5th, 05.
Yes, my lord.
0503/2024. 26, sorry. Okay.
Much obliged.
Item number 11.
Here also, my lord, this was listed for admission hearing, my lord.
This is for disposal.
Yes, my lord.
What about the IA?
IA, my lord, that IA was there for vacation of the interim order.
Hmm.
But on the last occasion, the IA has been treated as a counter affidavit, my lord. Our affidavit, and then on that basis, my lord, hearing was supposed to be done, my lord.
Hmm. What is the issue?
Issue, my lord, here regarding some incentive promotion, my lord.
Hmm.
So for employees of the company who were posted in Arunachal, in Dibang Valley, my lord,
Hmm.
now some incentives were given, incentive promotion, my lord.
Hmm.
And subsequently it was recalled, my lord, that policy was recalled.
Hmm.
Now the petitioner who was given that promotion as an incentive, my lord, is claiming that he should be given, he has got regular promotion, my lord. And on that basis, he cannot, that higher post, he should remain there and he cannot be rewarded back. That is the basic case of the writ petitioner.
Hmm.
Otherwise, our affidavit is that this was only an incentive. It is co-terminus with his transfer or posting outside of the state from that particular posting place. That is our statement. And as of now, the petitioner has been transferred to Bihar, and there is a order from the ministry also saying that this project has to be handed over to the NHPC.
So the transfer has been stayed.
Transfer was not state.
Lordship, I am for the petitioner. So my most respectful submission is that on 5/9/2025, there was an interim being issued by this honorable court where this interim order was not complied with by the petitioner, by the respondent company.
Hmm.
This interim order passed finding a strong prima facie case, my lord. But till now it has not been complied with. Instead, as a punitive step in nature, I was being transferred to another plant in Baksar, Bihar, PTPP. Now, my most respectful prayer submission is that, let me summarize in 3 points. Like, my accounts are been not settled yet till I am being transferred from here. And without the closure of the liabilities, company, as per me, company cannot be transferred. Company is transferred, that is their
Have you
internal
challenged that?
lordship.
You have not challenged that transfer.
That is a recent development, lordship.
If you want to challenge it.
And my account is not being settled. And then, my lord, ideal aspect is that the old policy which have been withdrawn and the new policy which is retrospective, that is very much silent about the service conditions of earlier employees who are already given benefit under the policy. And today they have filed an IA regarding the policy of their company's policy, lordship. The stay upon the impugned order, which gives me an interest intrinsically to be treated as general manager. I was DGM, then I was being promoted. Now I am transferred from here.
To as a what?
I am transferred to BTPP, lordship.
As a what? GM, AGM,
DGM,
DGM.
lordship.
Claim the order is in respect of withdrawal of certain incentive.
Incentive, yes.
Lordship,
On the
Well, here you We'll dispose of on some other day. Today it's not possible. All right,
Lordship,
madam.
the summary is that I was appointed as HR DGM.
It's okay. Today it's not possible.
Yes, Lordship.
Some other day.
Yes.
Kindly
City of
short
time.
a date may be fixed that means.
When you decide. And MS so and so learned
As Medhi, my lord.
learned counsel for the petitioner, and also Mr. D. Soki learned counsel for respondents.
4 to 9, my lord.
Respondents 4 to 9.
4 to
1, 2, 3.
I'm working.
1, 2.
Meanwhile, Lordship, the interim should be continued.
Has agreed to
Written date.
learn counsel for the parties. Let this matter be listed on.
March.
When?
18th.
And return.
Huh?
Okay. 30 or 31, my lord. Otherwise, ma'am. She's suggesting for 18, but I have some personal difficulty due to that wedding ceremony of 30 or 31.
There might be some cases coming up in principal seat of Guwahati. But 25th of March.
We will provide the date, madam. We will have a discussion and then we will provide the
25th
date.
of March.
Yes, my lord.
Date, we will have a discussion and
25th of March. Yes, next.
Obliged, Lordship.
Item number 12.
Interim order passed earlier shall continue.
May I please, Your Lordship,
Yes.
this is regarding suspension order, Your Lordship.
Affidavit not yet filed.
Lordship,
Affidavit has been filed.
pleadings completed. Affidavit in opposition, and I have also filed my reply as well. So the matter is fixed for hearing. So Lordship, the facts in the present case is that, Your Lordship, I
Not
was,
possible today.
Lordship,
Heard Mr. A.K. Singh, learned counsel for the petitioner, and also heard
I'm for respondent too, man.
Peter Abum, learned counsel, learned standing counsel, education department.
Yes, my lord.
For respondents. The pleadings are complete. As agreed to learn counsel with parties, list this matter on when?
24th, Your Lordship.
24th of what?
24th of this month, Your Lordship. The issue is very simple, Your Lordship. The suspension was not reviewed in time. That was reviewed back date.
For you, it may be very simple. For the court, it's not that simple.
Lordship, subject to Your Lordships.
You have one way. We have to
Yes,
control the
yes,
two
yes.
way.
Of course, Your Lordship.
Two sides we have to control.
Let it be on 24th, Your Lordship. Yes.
24th.
Yes.
To read my notice, item 11, we have agreed on 30th of March.
30th March.
March.
Okay.
For admission hearing.
Highly
Obliged.
Item number 13.
May I please, boss? Well, the pleadings are over. It may be fixed for admission hearing on some other day. It's
What is the matter?
matter is regarding, my lord, the settlement of pension, my lord.
Okay. Heard Mr. H. Lampu, learned counsel for the petitioner, and Mr. I also heard Mr. El Permen, P. Sangeeta, learned state counsel, standing counsel and learned state counsel. Pleadings are complete. List for admission after 2 weeks.
My lord, let it be on 2nd of March, my lord.
2nd of March.
Excuse me. Obliged.
Item number 14.
May I, Lordship?
Yes.
Lordship, service upon the private respondent, Lordships. This court allow me to take the dusty service, Lordship. On the basis of the order, Lordship, I taken the dusty service, Lordships, and dusty service is completed, Lordship. Service upon the private
Have you
respondent.
filed the affidavit?
Yes, Lordship. To that effect, I filed
the affidavit, Lordship.
Where it is?
Lordship, additional affidavit, in form of additional affidavit, Lordships, I file the service upon the respondent number, private respondent, Lordships.
Where it is?
Lordship, order, petition is available in the Lordship copy. Today morning, Lord, file this affidavit, Lordship.
It's not. And the heard Mr.
Jeevam, Lordship.
Jeevam, Learned Counsel for the petitioner, who has filed an additional affidavit showing the proof of service of notice upon respondent number
6, Lordship.
6 by Dusty Mott. Mr. Next perusal of the affidavit indicates that who has received this?
Received by a proprietor himself.
Received. The notice has been received by the respondent number 6.
Yes, Lordship.
Mr. Recording service respondent number 4. 6 is complete.
Lordship. Lordship, interim may be continued, Lordship.
Matter after
1 week.
After 1 week.
Lordship, affidavit is required from the government side, Lordship.
We should see.
Lordship, interim may be
Mr.
continued.
The Learned Standing Council, BP chair, Learned Standing Council, RD is present. Who is granted present and is granted 2 weeks time to file affidavit.
Lordship, picks that may be given, Lordship.
Why?
Lordship, it's a tender matter, Lordship.
It's after 2 weeks.
Okay.
Let them perspire.
Much away.
Item number 17.
Interim order passed by this.
17.
Yes.
Previous Lordship. Lordship, today is for consideration of my interim prayer.
You are supposed to file IA for implement.
Not me, Lordship.
Who?
It's them.
My Lordship, give more time for filing implement applications. A senior was instruct me.
I am unable to understand how are they affected by an association?
Huh?
How are they affected? It's between the registrar and the association. It is between the registrar who has cancelled our registration certificate.
Then?
Without giving any opportunity of hearing. Only for.
Who are you?
I'm the main complainant, Lordship. We have filed caveat application.
Caveat?
Yes, Lordship.
You are not party?
Yes.
No.
A week's time will grant.
But at least interim protection.
What interim protection?
The cancellation order.
Huh?
The cancellation order, impugn order, by which our registration certificate has been cancelled.
We'll consider. Let them file. We'll hear.
Already 2 weeks given, Lordship.
We have to receive our instruction.
On Mr. Learned Counsel for the case action, Learned Counsel for the petitioner.
23.
On the prayer of Ms. P. Sangita, Learned State Council, and Mr.
BC on behalf of Tita.
Learned Council, no. Further 2 weeks time is granted to file affidavit, File affidavit. Mr. So-and-so, Learned Council. Also, I was granted further 2 weeks time to file implement petition, application, if so advised. Just after 2 weeks.
Let's fix that may be given. Lots of interim prayer may be considered on the next date.
Interim prayer shall be considered on the next date.
2nd of March. Obliged.
Item number 25.
Request your lordship,
Yes.
on behalf of the petitioner side.
Hmm.
And the today itself, afternoon time, the respondent number 3 filed the reply and same is received by myself.
Hmm.
So in regard of this reply, I take some times to file the
Heard Mr.
M. Bagra.
M. Bagra, Learned Counsel. Your name is there.
Yes, your my lord.
Item 20.
5. Gopal Hemi. ठीक है तरह से Gopal.
I don't find your name.
In wakalat number, my lord.
Your name is not reflected. As a petitioner, Jyoti Jonglolo, Tozam Mosang, Punai Wang, Tamlora Lanum Senem. You file Wakalat number.
Yes, in the wakalat number, in my name is dear my lord.
Okay. And Mr. No, on the prayer of Mr. M. Bagra, Land Council for the petitioner. Let this matter be listed after 2 weeks so as to enable him to file affidavit in reply
Counter. Yes.
to the affidavit in opposition filed by
Respondent number 3.
respondent number 3. Amen.
Item number 26 and 27.
My lord, this is an objection against the creation of new village. Objection of the creation for new village.
New bridge.
New village.
Okay.
New village, because that land is under dispute, which is pending before this court under in the petition number.
Any affidavit?
Your worship, we are yet.
The IA is for what?
IA is for interim against the respondent who initiated for creation of new village called Dobum, that is under which falls under Kanku Circle and Likavali Circle. The land is under dispute. So they have initiated a letter to the deputy to the SP of Lower Siang for creation of the new village for permission. So lordship, here in page number my IA page 31. This is the letter issued by the respondent who is in main case of written 217. That is respondent number 7, 8, 10 and 14. They have initiated that letter to the Superintendent of Police, Lower Siang District, Likhavali, Arunachal Pradesh, regarding recognition of new village called Dobam. With utmost respect, we'd like to inform you that we are 7 households who are residing at Dobam village, carving out from Kamcham village for meeting basic amenity of rural life and as per census. New creation for recognition of new village needs feasible report for providing manpower of combating law and order problem in the new proposed village. So therefore, we request you kindly to needful and favorable action from your kind in. Lordship, here now they have enclosed the certificate from the head Gangbra, GB of NOC, that's GPC NOC, sketch map, PHC and water supply feasibility report, electricity feasibility report and all. So this was initiated by respondent number 7, which is main case in 217 of 25, read petition. And respondent number 8, respondent number 10 and respondent number 14 there. Lordship, thereafter according to this, they have enclosed the page 32, Lordship. Of my, this is the to whom it may concern. This is the report issued by GPC. This is to certify that the new village Dobum is carved out of Kamcham village POPS Likhavali under Kanku Circle, Lower Siang District. The said village consists of 7 households with 30 souls of bona fide APST. This is to certify issued for the creation of the new village Dobum and their territorial jurisdiction is free from all encumbrances. Whereas there is dispute in this land, which is pending before this court. And the Deputy Commissioner has also issued a status quo. 2020-21, and after in the main case, after passing status quo, DC has issued LPC 367 number of LPC, which is beyond his capacity. Lordship, here and next, Lordship, feasibility
for the respondents.
May I please, my lord? I am for the respondents 7, 8, 9, 10, 11, 12, and 14. They have filed IA, but my lord, I have not received any IA copy.
You punish him. I have punished her.
Sure. Lordship, here,
and Nabam Regum.
so matter may fix tomorrow, Lordship. I'll
Let
just
them
pass.
file an objection. It is submitted by MS Learned Council for the respondent.
He must be, Lordship, he must be private respondent. Otherwise, government
the private
respondent we have served already.
Yes.
Number?
Sorry, my lord. I am for the private respondent 7, 8, 9, 10, 11, 12, and 14.
Why not 13?
13, no, my lord.
13, why not? Who is 13?
I don't know. They also, yes,
Why you jump to, from 12 to 14?
14, yeah, 12 and 14 only.
Not 13.
Not 13, my lord.
Why not 13?
For it, I have no answer, my lord.
Who submits that she has not been received the copy of the interlocutory application, Mr. Mr. Regum Nabam
Arnabam.
Arnabam to fund an unconsumable petitioners to furnish the copy of interlocutory to
Lordship.
MS Swench, huh?
Only the private respondent.
Ah.
Rest state I have already served.
This the matter after 2 weeks for consideration. In the meantime, they may file objection. All right, 2 weeks.
Lordship, 1 week, since they are going to construct a house.
Okay,
in the
1
dispute
week.
line.
Okay,
1 week.
1 week.
2 weeks, my lord.
No. Since,
Please, madam.
since they are, Lordship, they are going to construct, they are changing the geography of the
Minimum time, reasonable time, 14 days, 2 weeks.
2 weeks, my lord.
Since Lord, this
One
IA.
week is too short.
Okay.
Minimum reasonable
Yes.
time is 14 days.
Lordship.
Obliged.
Item number 28.
May I please, Lordship?
Yes.
Lordship, due to the paucity of time, this matter may be listed after 2 weeks, Lordship.
Why?
My senior instructed me to.
Huh?
My senior instructed me to.
Similar method has been issued, decided. Matter could not be taken up for hearings due to paucity of time. As agreed to by Land Council, Mr.
M. Lago.
Or respond petitioner.
Yes.
And MS P. Singh, Council. That this matter will be still up to 2 weeks.
3 weeks.
3 weeks.
Problem.
Item number 29.
May I please, Your Lordship?
Yes.
On behalf of the petitioner. Your Lordship?
Some other day.
Yes, my Lordship.
Some other day, not today.
Oh.
Another day.
It's a short matter or what?
No, it's take time, Your Lordship.
Due to
Okay.
paucity of time, matter could not be taken up. Mr. M. Bagra, Land Council for Petition, and Mr. M. Kathur, the PAG, are present and agreed that matter may be listed after 3 weeks.
My Lord, because this matter filed under 2021, if possible, after 1 week,
2 weeks.
fixed it. If
2 weeks. 2 weeks.
Item number 30.
2 weeks on, you just give the date. 2 weeks on After 2 weeks?
5th of March.
5th of March. Yes,
If possible, 4th March.
4th March. 4th March is holiday.
6th March.
6th March.
Yes.
Much obliged.
Item number 30.
No time.
Yeah.
No, not time.
I have.
I'm seeking adjournment today.
I am filed a
When?
petition
When do you want? Not today.
just today.
What you have filed?
I filed a affidavit.
Affidavit.
Yes, sir.
When you would like to take, when we should fix the matter?
Yes, yes, sir.
When do you want?
Just a minute.
It's not possible today.
Yes.
So when? After 2 weeks, 3 weeks, 2 weeks.
Sir, I have filed.
Mr. Dr. Satish Kumar,
Yes, sir.
petitioner in person,
Yes. Sir, I have filed.
is present, and as well as Mr.
Arnabam, standing counsel.
the university.
Sir, I have brought all the papers which you have instruction to me, sir. I have brought all the papers, documents.
We'll consider some other day, not today.
Okay, okay.
Time submit.
Right.
It cannot be taken up today.
Yes, sir.
After when? After 2 weeks, 3 weeks,
2 weeks.
2 weeks.
Close.
No, heard Mr. Dr. Satish Kumar, the petitioner in person, and Mr. Arnabam, standing counsel for university.
Rajiv Gandhi
University, as well as Mr. M. Kato, learned
This day.
DSGI. For the respondents, as agreed to by parties, let this matter be listed after 2 weeks.
Yes, sir.
On when? Any fixed date you want?
Yes, sir. 2 weeks.
Okay.
I have brought all the papers which you have instruction to me, sir. I have brought all the papers. Orders.
Okay. It's a partner matter order. No. It's not partner matter.
No.
Okay.
Item number 31.
Malad is consented by the other party if Malad subject to Malad the lordship convenient. Malad matter may be fixed for day after tomorrow, Malad. Small matter, Malad, otherwise. Small matter, Malad. Service matter, Malad. My juniors are being promoted to the post of the junior assistant engineer, even to the Malad, the post of the executive engineer, Malad. Whereas we are senior most junior engineer serving in the department. But our Malad, the right to be promotion for has not been considered, Madam. So therefore, Malad, subject to Malad, the convenience on the part of the other party also is consented by them.
Why your juniors are being promoted when you are not?
Malad, one hand they are saying that it is part the internal arrangement, and the other hand they are saying that no, we are not appointed them as Malad, the regular junior engineer, Malad. So therefore, Malad, the matters needs to be considered, and the issue is Malad very small, Malad. Day after tomorrow, subject to Malad.
After the week,
Malad. Then in that case, Malad, may I pray that Malad matter may be fixed on 24, Malad.
M. Kato, learned counsel for the petitioner, and also Mr. Vairam, learned state counsel. As agreed to by parties, let this matter be listed on 24.
Correct, Malad.
24 to 2026.
Unlisted item number 32.
So.
32 and 33.
Here, my lord. My lord, I seek to withdraw the matter with a liberty to file a fresh matter if necessary.
Different, separate order, but same order. Mr. Arsek, land counsel for the petitioner, submits the He may be allowed to withdraw this petition with the liberty to file first. Very long. Writ petition is accordingly to the stance close with the liberty to express for her.
Correct.
Separate order, but same order.
Listed item number 33.
I may be allowed to withdraw this matter.
Without
No.
no liberty.
Yes.
It's Mr.
M. Lago.
Learned counsel for the petitioner. Some mistake, he may be allowed to withdraw this. He has an instruction to withdraw this writ petition. Mr. Accordingly, this petition stands closed on withdrawal.
Oh, Mr.
Over.
It was over last time.